Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 12th, 2025. We have 13 bills on the docket, and we're going to start off with Senate Bill 630. Mr. Chief Justice. Welcome.
Okay, Chair Smith, members of the committee, thank you very much for hearing us today. This is a bill that is aimed at increasing public trust and confidence in the judiciary, minimizing perceived conflicts, and ensuring that every judge in the state has been thoroughly vetted and found most fully qualified by a neutral panel before taking office. All judicial vacancies in Maryland currently are filled initially by candidates who complete extensive applications about their background and qualification, undergo a rigorous interview process with local and specialty bar associations, and then get thoroughly vetted and interviewed by a judicial nominating commission charged with identifying the candidates who are most fully qualified to hold office. Those candidates are then forwarded to the governor, who does another round of interviews and vetting before selecting an appointee. It is an appropriately rigorous process for such important positions. After that, however, the processes diverge based on the level of court. District court and appellate judges are subject to confirmation by the Senate. Appellate judges then also sit for retention elections, which they face every 10 years if they are successful the first time. Circuit court judges are not subject to either of those checks. Instead, they run in contested judicial elections where they can be challenged by any lawyer who meets the minimum constitutional qualifications. The winner gets a 15-year term in office. There are several aspects of this system that can be problematic. One is that the job of a judge is, or at least should be, inherently apolitical. Judges are charged with being impartial arbiters of disputes and with maintaining neutrality at all steps of the process. That's essential to public trust and confidence in what the judiciary does. A second is what comes with fundraising for a judgeship. The primary contributors to judicial campaigns, not surprisingly, are lawyers, often the same lawyers who appear before the judges. This poses a challenge for public trust and confidence as well. A third challenge is that candidates are subject to differing rules based on whether they're a sitting judge or not. Sitting judges are subject to ethical guidelines that restrict what they can say in a campaign that do not apply to challengers. And a fourth challenge is security. Judges knocking on doors, encountering people who have been before them in cases, or family members of people who have been before them, can result in dangerous situations. This bill would replace the current system of contested judicial elections with essentially the same system that's in place now for appellate judges, subject to Senate confirmation and retention elections on a 10-year rolling basis, while eliminating aspects of the current system that are challenges to public trust and confidence in the courts. This proposal comes out of the work group to study judicial selection. 2 members of that work group are here today with me to testify. We are very appreciative of the work of all of the members of that work group who came with their own varying experiences and varying positions. And I believe you'll also hear from some other members of the work group who've taken a bit different position later today. With that, I will turn the microphone over to one of the, who's speaking first? To one of the co-chairs of the work group, Judge Kathleen Dumais. Thank you, and I look forward to your questions, and thank you for your consideration.
Good afternoon. It's nice to be back before this committee. Since I was just here Friday, though it was virtually, it's much better to be here in person. And thank you for the opportunity to be able to speak about this bill. As Chief Justice Fader said, Judge Alex Williams and I served as co-chairs of the Judiciary's work group to study judicial selections. I think it's important to note that what the work group did was study selections from start to finish. This was not a work group to just talk about elections. Over the course of a 22-month study, we've completed a fair, balanced, exhaustive examination of various methods of selecting and retaining appellate and trial judges throughout the country. We reviewed and analyzed academic literature and research from a myriad of sources, such as the Brennan Center for Justice from New York, the National Center for State Courts, the Sandra Day O'Connor selection plan that was developed by the Institute for the Advancement of American Legal System, which is out of the University of Denver, the American Bar Association, and other academic resources. The broad work group membership included representatives from the community and advocacy groups outside of the judiciary, representatives from the business community and academia, and attorneys and members of the judiciary. We met 8 times and importantly held a public hearing for stakeholders and citizens so we could hear perspectives about all of this. We started from a blank slate. The focus of the work group was on the best practices to ensure selection and retention of highly qualified judges who reflect the community. The work group recommendations are data-based and research-driven. Based on the study, the work group recommends that Maryland makes a change to our judicial selection process, and all of that's outlined in the report. If you don't have it, I'm more than happy to send it to you. In the testimony for today, a sort of 2-page summary is included in the written testimony that was submitted today. Chief Justice Fader explained what the bills do. Instead of a 15-year term for circuit court judges, it would be 10 years. It would be by a retention election after Senate confirmation. One of the important pieces that we looked at were the judicial nominating commissions, and we heard a great deal about those. At the moment, they are, in fact, and still, appointed by the governor. But what we included in our recommendations, and some of the recommendations were already adopted by Governor Moore, because his staff was aware of what we were working on. So we believe the judicial nominating commissions did need some additional work to make sure that they were transparent, that they were open, and that public had the opportunity to talk to people at the Judicial Nominating Commission. So I urge you to read the report. There's my time. Sorry, guess I'm up. But it was one of the work group, again, was very broad-based. We made sure that we had people with diverse opinions, and you'll hear some of those today, all of which is important. But what was overriding to us was finding a selection process that would, in fact, ensure that judges are qualified, impartial, and independent. And we think the model that we're proposing is the way to go. provided that there is public input at appropriate places. And we hope that you'll consider this bill seriously. Happy to answer questions or talk about it further. Thank you.
Good afternoon, Chair, members of the Senate Judicial Committee. Let me focus just for a second on the Judicial Nominating Commissions. As some of you may know, I served as the chair of the Appellate Judicial Nominating Commission for just about 8 years, and that process is still very, very effective. And what the Judicial Nominating Commission does, they, of course, encourage and identify applicants. They review the applications. They vet the candidates. They hold a hearing, and they make certain determinations based on integrity, maturity, temperament, diligence, legal knowledge, and experience. The several governors across the years have changed it from time to time, but essentially the procedure, again, calls at the present time for Governor Moore's executive order to consist of 17 members and 12 appointed by the governor and 5 by the Maryland State Bar Association members appointed by the governor from a list of 10 people and selected by a Board of Governors Executive Committee. After hearing so many comments for and against the Judicial Nominating Commission, the workshop understood the need to broaden the inclusion of citizens, diversity groups, and specialty bars to make up that composition. And so our recommendation, which is set forth in the report, includes broader input and more meaningful representation, including the specialty bars on the commission, to avoid conflict of interest by commissioner members, to assure that the composition of commissioners shall fairly and appropriately reflect the minority, ethnicity, race, and gender population from the areas from which they are appointed. Finally, accommodations for commission and judicial applicants with disabilities must be looked at, and the training of commissioners also was important to us. So all that is set forth in our report, and we'll answer any questions you may have. Thank you.
All right, good afternoon. I'm Judge Cherie Simpkins from Prince George's County, Maryland. I stand here before you today to strongly advocate for the elimination of judicial elections. As you know, the Maryland Maryland has a rigorous judicial selection process, of which I had to undergo twice, once as a district court judge and now as a circuit court judge. Yet, despite the thorough evaluation process, our system allows individuals with little to no legal experience to challenge sitting judges in election. Maryland circuit court judges are the only judges subject to contested elections, but we must run against opponents who need only meet the minimal qualifications of being a licensed attorney, residing in the county for 5 years, and paying a $50 fee. This means that the judges with decades of experiences, like myself and my running mates, could be challenged by individuals with significantly less legal knowledge and courtroom exposure. In my race that I just ran in 2024, my former running mates and I had over 20 years of legal experience, and we were forced to run against a candidate who just graduated from law school and had 3 years of legal experience and passed the bar in 2019. Again, this individual did not campaign at all. He had no information out there. However, he received 127,711 votes just by ballot placement and where he was on the ballot. They did not know about his qualifications. And this stark example highlights how judicial elections do not prioritize qualifications or merit, but instead rely on name recognition, ballot placement, and voter unfamiliarity with the judiciary. Furthermore, judges are not politicians. But in order to retain our seats, we must take time away from our already heavy caseloads, using personal time and leave to campaign, ensuring that justice is served. However, we are engaged in political contests that diminish the integrity of our judicial system. Furthermore, judges don't receive security protections, making public campaigning a significant safety risk, especially in cases involving sensitive matters like domestic violence and violent crimes. Also, unlike legislative and executive races, where candidates campaign on policies and platforms, judicial races are inherently different. Judges cannot make promises or take policy positions. Most voters do not have direct interaction with the court system and don't understand that and are often unfamiliar with our role as judges. As I previously stated, the ballot where our person was who ran against us was third in line on the ballot, and he was able to secure so many votes. I implore you to do away with the elections. The integrity of our judiciary should not be subject to political whims. Judicial elections compromise merit-based selection, force judges into political roles that we should not be in, and allow unqualified candidates to challenge experienced judges without meaningful voter scrutiny. And we must move away from this flawed system. Thank you.
Good afternoon, everyone. I'm Phoebe Berry, one of your circuit court judges. Thank you for letting me address you. You know, preparing for 14 interviews for appointment is no joke. I remember standing at the mirror or in my car talking to myself, asking random interview questions, or on the floor at 3 a.m. in the morning studying. I went back to law school. Not just to prepare for the interviews, but to prepare for the job. I lost so much weight that people were scared for me. It was brutal. And it was okay because it tested my mettle. I got through it, I took the oath, and I meant every word, and I did the work. I posted by my door Maya Angelou's words: people will forget what you said, people will forget what you did, but people will never forget how you made them feel, and I did and do my best to live by that daily. Almost a year later, we were still fighting to keep doing the work. My 3 colleagues and I took days and days off to campaign. We didn't mind taking off, but 4 of us were just gone. Last slate, it was 7. That doesn't hurt us. It hurts the community because a ton of cases can't be heard. Then we got to the results, and I was the very top vote getter on the Democrat side. On the Republican side, I was dead last of the 4 Governor Hogan appointees. The other 3 were white men. It wasn't our integrity, wisdom, or sound legal knowledge. It was something else having nothing to do with those things. I was lucky. My colleagues were lucky. In other counties, not so much. So I am asking, please do something to make sure that your judges are seated based on merit, because our community deserves that. Thank you.
Good afternoon. I'm James Rhodes, one of the circuit court judges for Baltimore County. On January 26, 2024, I was sworn in as a circuit court judge. I'd given up a very successful law practice that I had built over 2.5 decades. I was serving my community outside of my job as an attorney. Monthly, we were providing services to the unhoused in Baltimore City. We continue to do that, and I was doing that for over a decade prior to coming to the bench. When I came to the bench, it was one more opportunity for me to serve that community. Within 2 weeks of being appointed, I learned that I had to run in the election, potentially giving up everything. I had no career to return to that I built up for so long. I had no vast amount of income that was already there preparing me to restart practice anew. When we went through that campaign, I want you to understand what we went through. I had There were 4 of us running and 1 challenger. I had fabricated stories placed online, had voters informed that I was a criminal at the polls. There was 1 ad that when you opened the ad or when you initially saw it, there was an African-American male pointing a gun directly at you. This was specifically pointed towards me, and it was based on an incident where my son was almost killed, and I had to defend him at my home. The challenger was able to disgustingly falsify that incident and use it in a manner that judges are not able to. There were attempts by the challenger to place personal information of judges online. He courted that the entire time. The safety, the integrity of all judges is at risk when we continue these contested elections. Like my colleagues, our spouses were out at the polls as well. Spouses were threatened. Spouses were subject to name-calling and other unnecessary acts by the challenger and his staff. How do we expect to have some of the best and brightest among us apply to these important positions when many simply do not want to risk what could be considered an unfair election challenge, negative attacks on our families, and giving up successful careers that have been built over decades? I simply ask that you consider and reconsider your positions on contested elections. Thank you.
Excellent. Thank you all very much. Questions from the committee. Senator Henson and Senator Folder.
Mr. Chairman, thank you all for sharing not only your expertise, but some of your personal experiences as well. I think you will find a sympathetic audience here in terms of the rigors of running for election, the challenges of knocking on doors and never knowing what you'll be received with on the other end, having negative mailers and attack pieces that have your faces, your family's faces, having your spouses, your children at the polls with you, and never knowing how they are going to be received or treated in public. I think you'll find a group of folks here who understand all those challenges uniquely. My question is for Justice Fader. Specifically, my concern, I think we have seen, and it's no longer a theoretical exercise, of what happens if the checks and balances are collapsed. If you have a very strong executive, that executive has allegiance out of the legislative branch, you really need a strong judicial branch to really continue the checks and balances of government. If that judicial branch is now under the bill, appointed by the governor and confirmed by the legislative branch and runs only in a retention election, my concern is that we are losing that opportunity for the public to come in and be that check and balance, to make sure that that judicial branch isn't just lockstep with the executive, but to make sure we do have some impartiality there and people who truly are vetted by the public. How can you help talk me through or around that concern about collapsing the levers of power?
I can certainly try. Thank you. I'll first say that I don't think that the current system really provides that. I think that there's an absence of a lot of information about the candidates there. I also think, frankly, the nature of the judicial position and judicial campaigns is the judges who are campaigning aren't allowed to weigh in on political issues. So to the extent that you're asking whether the public should be aware of the political leanings or ideology of the judges, that's something that right now we have nonpartisan elections, and that is information that a judge shouldn't be conveying and shouldn't be part of choosing under our current system. I think that the best way to create a strong and independent judiciary is to have a selection process that instills public trust and confidence in the individuals that are selected. The one that we have in place, beginning with judicial nominating commissions, assures that that as long as the rules as far as who's supposed to be on the judicial nominating commission and what their charge is, which is to identify the individuals who are most fully qualified for those positions, that when those selections go up to the governors and the governors pick from them, only the people who are most fully qualified, that's the best assurance for a qualified, nonpartisan, independent judiciary. So I think this is actually calculated to get to that, what you've described as that important check by an apolitical branch that is expected to be and takes great care to be nonpartisan and apolitical.
Let me, if I may, add to the fact pattern that you suggested about not being able to make statements about certainly things that are political in nature. Let's say we had a chief executive who excluded certain people from serving as judges. I know in my county, Anne Arundel County, our court had over a 360-year history where no black woman had ever been selected to be a judge on our circuit court for 360 years. And it wasn't until 2016 when a black woman put her name on the ballot and challenged the sitting judges. She didn't win that election, but the next time the governor had a choice to make, the governor appointed a black woman as the very next judge of the circuit court. I and a lot of people are of the opinion that had that woman not run, we still would be excluded from serving on our circuit court here in Anne Arundel County. So let's say you have a chief executive who wants to exclude certain people and you have a legislature who's complicit. Under that scenario in this bill, where would the opportunity come from someone in the public to be able to still push forward for progress and challenge?
As with the checks and balances in the system that we have now, I think the greatest part, the greatest availability to make change, even now and under that system, is through votes for the elected branches, which then are the source of the nominations and the approval of judges as well.
Okay, thank you for your response. Thank you, Mr. Chair.
Thank you, Mr. Chair. So for whoever wants to answer this, I kind of have similar concerns that my colleague has about the process of this and how it separates the two branches and keeps that balance in place, because I don't see it. I see where you have an opportunity for where we already have a supermajority in this state. We're literally taking away, while we have a supermajority in this state with a concentration in the central part of the state of many, many voters or one political leaning. But if you look across the map of the state, the counties are reflected differently than that supermajority populace and the concentration. So the question is, how is this bill not taking away the representation of the local beliefs of the local population and leaving it to the selection of the governor?
I'm going to give it a try, and then certainly if Chief Justice or anyone else on the panel wanted to. But I wanted to talk a little bit about what we reviewed in the work group when we looked at all the academic research and heard from Brennan Center for Justice and several of these others. No one is suggesting that politics isn't part of whichever selection system we decide. What we were trying to determine is what is the best selection process to ensure that we have qualified, impartial, independent members of the bench. So I have, as most people know, I was in the legislature for 19 years. I've run 6 times, one of them as a judge, the other 5 for the House of Delegates. But I think what is important to note is that when you're running as a legislator or a policymaker, your role is different than that of a judge. And if you're bringing before the court your family issues, your criminal issues, question of loss of your liberty, business contract, or business, breakup, what you want to be sure is that the judge that is before you, and at least this is where most of the work group came down, you want to be sure that person is vetted and is highly qualified. Now, my experience, and I will tell you some of this question of, if it's a governor that is making the appointment, is that going to be partisan? It was actually Governor Glendening who started the entire discussion about we need to make sure that the bench reflects the community. And it was his legal counsel, who is currently actually on the Appellate Court of Maryland, who wrote multiple articles about and using the JNCs, the Judicial Nominating Commissions, properly. Most of the governors, and I was elected when Governor Ehrlich was first elected. I was here for the 8 years of O'Malley and then for the years of Governor Hogan. All of the governors that I've spoken to take the responsibility of selecting judges as one of their most important roles. And when they're making these selections, they're not making them on partisan basis. Now, do sometimes Democratic governors do more Democrats? But I will tell you, O'Malley appointed Republicans. Ehrlich and Hogan appointed Democrats. I'm an example. Governor Hogan appointed me. And they do reflect the community. Now, who applies? One of the roles of the Judicial Nominating Commission is actually to recruit people to apply. We are having trouble getting people to apply. And as was mentioned, sometimes it's because they don't want to give up a practice and run for an election and then not have a practice to go back to. Now, I would have been fortunate. I had a firm that would have taken me back. Not everybody does. But the decision that the work group made was that it was important to get to a place where the selection process included vetting these individuals. But we want public input, and that's where some of the recommendations in the report talk about more public input at the JNC level, where public should have access to the Judicial Nominating Commission, should be able to submit information to the Judicial Nominating Commissions. We want the public to be educated about who is going to be on the ballot and who is going to be making these very critical decisions. Not in a, it's not a, policymakers, you're here appropriately, you're doing it in a collaborative fashion. You're making policy and you need whatever number of votes to get a bill across. When I'm sitting on the bench, the only person that's making the decision is me. And if I've got a family member that's going to be before a court, I want to be sure that I want to know that that judge is highly qualified. So that's the answer is there should be public input, but there are other ways to do it.
And I appreciate the answer, Judge. So the question I have is that, again, that brings me back to it. Here's the overwhelming reality of the environment that we sit in. We have a supermajority body that runs the way the state heads. If they want something to go through, it goes through, whether my citizens or I object. If they don't want something to go through or they want to kill one of my bills, they kill the bill because they have the numbers to do it. And what we have is we're seeing this in, it is, unfortunately, the reality is subject to political whims. It is. And the secretarial appointments are a key example, a prime example of what I'll tell you. Look at the secretarial appointments we have. I have people that come in, they'll object or they'll say something about it. It doesn't matter. It's going to happen. It goes through. The governor wants it. It's going to happen. It doesn't matter. The vetting process that you talk of, the qualified impartial members of a bench, there's a minimum standards to run for that position, to be in that position, to serve in that position. So as long as those minimum standards are met, the qualifications are in place. Whether or not you agree with those qualifications is irrelevant at this time unless you want to bring something forward that says you should have more time on the bench or I'm sorry, as a litigator or whatever. That's a different discussion. But there's already minimum qualifications
that are in the Constitution. You're right. Correct.
They're already in place. So that's why I'm trying to figure out what, someone brought up about the merit that they seek. What is the merit you're seeking? What is the merit my representation, my constituents should be seeking when it's when the governor is the one that appoints it and probably isn't going to appoint it to their liking?
Although I have to admit, again, the judicial nominating commissions are based on the community. So if you are in a community that is, on the Eastern Shore or in Western Maryland, and the party division is a little different, your Judicial Nominating Commission is going to be sending names forward where they have recruited, don't have to be recruited, but might recruit And then, and again, I don't know the party of some, but I do know that there are multiple Republicans on my court that were not necessarily appointed just by the Republican governor. It is truly the governor's looking at what is the best, I want to know, that's what the JNCs are doing. What is their practice like? How long have they been practicing? What is their academic background? What's their involvement in the community? All of those things make up sort of who do we want? Do we want a candidate sitting on the bench that has been vetted, not only by the Judicial Nominating Commission, but by 14 other bar associations, and then the governor's office that does an entire other vetting process? Yes, I'm sorry.
Yeah, sure.
Let the Chief Justice.
Thank you. So let me just say, the concerns you're raising are all completely valid. And as I think has been said here before, there's no perfect system that has been designed for this. And the question is, how do we get to the best system that we have? And the other thing I'll say is that there are cycles, of course, and one way to address that is of course, the cycle. We have governors who switch, just as in the presidential level, for different parties. And the concerns you're raising under one governor may be completely different under another governor, and that's the normal cycle of the political process that gets there. But the judiciary is best when it operates outside of that process in an apolitical way.
So, and I appreciate that. Thank you, Chief Justice. So I'll close out with this, Mr. Chair. I have one last thing, and that is, I put a bill in, and I hear this across the board. I put a bill in, so I'll say 6 years ago, I was viciously and maliciously, with intent from the Democratic Party, with false flyers, bad information was put out, trying to just tear my name down with malice of forethought, knowing it was not truthful. So what I'm hearing is, and I would love to have the judiciary chime in on this, is I then put a bill in that required truth and accountability. Because like someone said, there was something that was put in. So in legislative matters, in elections, because they matter, the truth is important. When I put that bill forward, it didn't even get a vote in committee for truth and accountability for those operatives within the party that purposely put out false information with the attempt to assassinate one's character. And because we're running for office, we're a little different, right? We're not protected. We're for slander and all this other stuff, even though it's known to be false. And no one in this body wanted to pick that measure up. So wouldn't it make more sense that if we enacted such legislation, like if this doesn't move forward, to put something in that says if truth and accountability matters, especially in the judges' appointments or elections or all of our representatives, citizen representatives? I mean, doesn't that make sense to you as well?
Senator, I can't speak to any other bills, and I can't speak to your experience. I can say the truth-seeking function of the judiciary is one of our most important functions.
And that's what we're talking about, Chief Justice, is the impartiality and the truthfulness, right? Somebody brought it up, so I'm just bringing it up. One of your panelists brought up how they were assassinated with bad information and how it was, the reality is that's the environment we function in. But my concern is, and I've expressed it very clearly, is whenever we start having these discussions about taking away the public input and we leave it at the discretion of solely the governor, whoever it is, and overwhelmingly over the past 100 years, it has been one party over another, then the people that I represent aren't getting their fair input into the discussion. And when we start taking away, my vote may not matter down here. It's a joke all the time. My vote doesn't matter, but right? But my voice does. And when we start attempting to silence the voices of the representative body or those that we have the judiciary over, that's an affront to democracy. And that can never be allowed. Any impartial judge would agree with that. Voices matter. So, thank you.
Thank you, Mr. Chair. First of all, Judge Rhodes, could I exchange some questions, comments with you first? The person who ran against you last year in Baltimore County, had he applied to be a judge?
He had applied. It's my understanding that he had applied on a number of occasions.
And had he been recommended by the Judicial Nominating Commission to the governor for consideration?
He had not.
And as I recall, the standard for that is the Judicial Nominating Commission is charged with sending names to the governor who it believes are fully professionally qualified to become judges. So you met that standard, but your opponent did not.
Yes, sir.
So I want to express to you my profound regret of what you faced in that election last year. I was at a meeting in which the 4 sitting judges were present along with your opponent. And I will say, when the 4 professional judges spoke highly professionally, and when the opponent stood up, I have never heard such scurrilous accusations, unsubstantiated accusations in my life. I was so annoyed that I'm not sure whether you're aware of it or not, but I sent out an email to everybody on my list prior to the primary, fulsomely endorsing the sitting judges and calling you totally qualified. So I congratulate you on your victory. I congratulate you on the way you conducted yourself during the campaign, and you have my undivided admiration. I just wanted you to know that.
Thank you, sir. I also did want to slightly address, Senator, your concern about retention elections versus contested elections. In a retention election, the public still does have a say. For instance, and I'm somewhat simplifying this. Let's say you're in a conservative jurisdiction. You prefer judges who drop the hammer in criminal cases. And you have a governor who has appointed someone who may not be as conservative with respect to sentencing. Your community still has the right at the time of an election to know about that judge. I imagine you would certainly be one of the forerunners putting that information out there that this particular person who was elected does not represent the values of my community. The community, I'm sorry. Well, that's what I'm sorry. The person who's been appointed. So when it comes time for retention, in the election, all of that information would come out about this particular judge, probably more so than now, because in most of the elections now, when you have a group of judges that run, they run as a group against any challenger that comes out. A retention election allows you to specify which judge it is that you believe does not meet those same core standards of your community. So when they actually vote, they vote out someone that they don't believe represents the same values as your community. Each time they do that, you have a governor who's listening. I can't say that.
We don't have that.
I'm not very familiar with the political process. That's not what I do as a judge. It's not what I did beforehand. Senator, you may know, a number of the things that we went through in that election. I imagine that if one of us were in your community and we were doing things on the bench that you didn't want, in a retention election, you would be able to, the same way that you send out the emails to your constituents, you'd be able to do the same thing in a retention election and notify your constituents that perhaps this is not the person they want to retain on the bench.
Thank you, Judge Rhodes. Now could I ask a few questions of my old partner in crime, Judge DeMay? Just so people watching know, Judge DeMay and I have been excellent friends ever since I got elected to the General Assembly back in 2014. And we have the most wonderful relationship, intellectually honest and totally civil. So I've got questions, and in that spirit, I'm going to ask a few questions.
Of course.
So under this bill, the confirmation of a judge to the circuit court would be up to the Maryland State Senate. And
Correct.
As I understand the import of the bill, the governor would nominate a person, and the state Senate would vote to confirm or not, and the judge would be confirmed if the person got 50% plus one vote on the floor of the state Senate.
That's my understanding.
Okay. So currently, the governor's nominations for district court and for both appellate courts come to the state Senate for confirmation.
That's correct.
And they are confirmed if they get 50% of the votes plus one vote each on the floor of the state Senate.
That is my understanding.
All right, we're a quarter of the way through the 21st century, this being 2025. Can you tell me how many district court nominees of all the governors during this first quarter of the 21st century have failed to receive 50% of the votes plus one vote on the floor of the state Senate? How many?
None that I'm aware.
None. How about appointees to the
I'm sorry, within the last 25 years?
25 years, since the turn of the century.
My understanding, I think there was really only one, but I don't think it was, I think it was before 2000.
Okay. Let's turn to the appellate courts, appellate judges. How many of the governor's appointees to the appellate courts during the first quarter of this century have failed to receive 50% of the votes plus one on the floor of the state Senate?
None to my knowledge.
Okay. Let me go back to something you said. You brought up, I wasn't going to do it, but you brought up Paris Glendening and suggested that he was doing everything he could to avoid partisanship. So in the late 1990s, I was in a meeting in Baltimore County when Judge Robert Dugan, who was on the District Court of Maryland at the time, came to us, and he had filed his candidacy to run for circuit court. And he told us that he had applied innumerable times to be appointed to the court, and even though he was on the approved list sent by the Judicial Nominating Commission to the governor, time after time after time, the governor had passed over him until someone inside the governor's close circle who knew what was going on said, Bob, you're wasting your time. He'll never appoint you because you're a Republican. He doesn't appoint Republicans. So I was stunned by that, and I went back and I started researching and spent a considerable amount of time researching Governor Glendening's appointees to the circuit court. I don't know whether you're aware of the numbers. It was close to 120 by the time he left office after 8 years.
That's pretty normal.
And of that number, 4 were Republicans, a tiny percentage. One of them was from Garrett County, where only Republicans had applied. Another was an incumbent state senator from Carroll County who had done an important favor for the governor, and he got appointed to the circuit court. In other words, there seemed to be a special reason for each of the 4 Republicans who were uniquely appointed to the circuit court. Do you have any information which contradicts that information, which I believe is accurate?
I don't, but I also, your comment that he was told whatever is certainly hearsay. I have no idea who he talked to. What I do know is when I said about particularly Paris Glendening's appointments, is that it's when he started to look really at diversity, and making sure it represented the community. I don't have any specific information about the specific whatever. I can tell you the particular, and like I said, I know that his staff worked very hard on it. That's what I know, and that's what I said.
Great.
What I do know then is when I was elected and with Governor Ehrlich, and I've been, as a practicing attorney, I've been very involved in judicial selections throughout. I've never served on a commission, but at the same time, I work with those in my community. I'm often asked to sort of support one candidate or another, and I take whether or not I do very seriously. But I thought that Governor Ehrlich, Governor O'Malley, and Governor Hogan really did take this responsibility very seriously, and I happen to know that all of them appointed people from other than their parties. Now, do I know the exact numbers? No. But for instance, I have been told, this is also hearsay, that Governor Hogan specifically did not want to know a candidate's party. I think that's admirable, because it shouldn't be based on party. It should be, and that's exactly what the work group said. We want people that are highly qualified, that have been vetted, and that we are therefore, the other thing, it is unfortunate. There are some really good people that make it through and onto the list of these nominating commissions, but there are only so many positions. And that makes it difficult. And you're going to probably hear that's from members of the work group. We had, several that ran, and some of it is they made it through the commission. They didn't get picked, and they went just as Judge Dugan, who I don't know if he's here today. He's usually been here for almost all of the times when these bills come up.
I don't
and
see
I
him in the
understand
room,
he
but
was
you're
a
right.
wonderful judge. And I think the current judges that were elected were good. I'm just here to suggest that we need to look at the selection process to ensure that we have the most qualified, independent, and impartial bench.
Let me
that's
go,
what I'm here
thank
for.
you for your answer. Let me go back a little further in time because at my age, I can recall the 1970s and 80s.
Okay, I was in high school.
During
so
that
we'll see.
period, we had 2 consecutive governors, both of whom came out of Baltimore City, and they both had lots of good friends, many of whom they appointed to the Circuit Court for Baltimore City. Unfortunately, nearly all of their good friends were white males. And I'm sure you're aware the Monumental City Bar Association, after a while, got upset that even though Baltimore City was a majority minority community, the judges that were being appointed by those 2 consecutive governors were almost uniformly white males. And the Monumental City Bar Association started to run candidates against those judges, and indeed won quite a few of those elections.
I agree.
And so as a result of that, the Baltimore City bench became far more diverse than it would have been if we just had the white males on the bench. So do you have any reason to believe that the nominees appointed, that if this system that you're advocating today had been in effect in the 1970s and 80s, that Governors Hughes and Schaefer would not have been able to succeed in getting their white male appointees confirmed by 50% plus 1 vote on the floor of the Senate?
I can't really answer that hypothetical question. I don't know. Maybe, but again, I think times have changed, and what we need to look at is where are we today? And in the report that we submitted, we actually indicate exactly what the racial and ethnic, I can't say that, ethnic
breakdown,
diversity, and how our bench is diverse. Chief Justice said it, I think I said it, there isn't a perfect system. But our work group, after a great deal of study, feels that this is the best method and is in line with what a lot of other states do across the country and what the academic research suggests. Now, again, I think don't know what would have happened in the 70s. You may be absolutely right that this face of the Baltimore City bench wouldn't have looked any different. It does look different now, as it should. And the bench on most of the other jurisdictions also looks different, as they should. And that's the reason we're supporting this selection.
Great. I appreciate our opportunity to chat, as always. Thank you.
As always, I agree. Thank you very much for your questions.
Thank you very much. I was about to call you Delegate Dumais, but Judge Dumais. Good afternoon.
Another one of my former colleagues that I admire very much. I understand.
Earlier, you had mentioned something about public input in the Judicial Nominations Commission process. Could you elaborate on that a little bit?
So there were a couple of recommendations that we made, and I think we may continue to, there's some other things to consider. One of the recommendations is who is appointed to the Judicial Nominating Commissions and how are the appointments made? At the moment, and which has been in effect really since the 1970s when actually it was Governor Marvin Mandel who initially started the Judicial Nominating Commission process. The governor appoints most of the members of the commission. You have to apply to be a member of the commission, and the governor does the vetting of the applicants and then determines who is going to be on the commission. 5 members of each commission, I think at least of the trial courts, it might be more for the appellate court nominating commission, are appointed from a list that is submitted by the county bar associations. There have been some problems in how that has occurred, in that there are some county bar associations where the president appointed 5 people or sent a list of 5 people for the governor to choose from. What we recommend in the report, and we have sent the report to all of the bar associations, is that the bar associations, when they're sending the names, need to establish a selection committee to determine who should be the 5 names that are sent to the governor. The selection committee has to be broader than just the president of the county bar. It has to include members of all of the specialty bars in that jurisdiction. And it's that selection committee that is going to vet. People will then apply to the Bar Association, which they tend to do now, and then that selection committee is going to determine who the 5 names are going to go to the governor. The other recommendation is that during these Judicial Nominating Commission meetings, there should be a time where there is an open meeting where the public can come in, and whether they testify or whether they submit written testimony. Technically now they can submit written testimony, but it's not really done. They're getting what they get this Judicial Nominating Commission gets the reports from all of the 14 bar associations that everybody interviews with. It's the Asian American Pacific Bar, APABA, it's the Hispanic Bar, it's Monumental Bar interviews all candidates across the state. So does the J. Franklin Bourne Bar, the Maryland State Bar Association. In the report, the list of the various bar associations are there. So they get the reports or the recommendations from all these 14 bar associations, and then they may get other letters, usually from people the candidates have said, can you send a letter in? What we want is it to be even more open than that, and that it's not just the people that I've asked to send a letter, but also that there are others that can come and speak to the Judicial Nominating Commissions. I'll tell you that was kind of controversial in my little work group, or not little, it was rather large, because again, these are individuals that have been appointed and that take their role very seriously. And there was a little resistance, but I do think that's a place where there should be more public input and that we can do that. And that was part of some of our recommendations in the report.
And with that recommendation, and I know some of your colleagues testified to the fact that they have all these years of experience, and these others, folk who are coming to run against them, don't have that type of experience, and the public doesn't have enough information on us, and we can't act as legislators do and talk about policy and the like. So the question that I have is, if the public participation piece were to be expanded at the Judicial Nomination Commission's piece, what has changed for the public to engage? I mean, what new information is going to be out there that they're able to look at? And I think, sir, when I began serving on this committee, I believe one of my colleagues may have had legislation trying to open up and bring additional transparency to the judiciary and kind of put certain information out about judges' rulings and the like. I'm curious, did in this recommendation, did your committee look at what type of information is going to be out there that the public could then use to make intelligent decisions or recommendations?
We did. We looked. There are several states that have programs or processes in place to allow for evaluations of judges. But again, they're all states that have retention elections. And I do think public, and you'll see in the report, when we talk about retention elections, we also talk about public education. And I think there are a couple of things we can do to, do more public education. So, as I indicated, I've ran as a delegate for 5 times and then as a judge for the 6th. But I've always been involved in the sitting judge campaigns because I do believe in the sitting judge principle. And so I participated and would often campaign for the judges. And what I would usually find is that voters were, and I still get calls, although now I can't respond to them, who do I vote for from the judges? Because unfortunately, and I was very involved in my community and in my district, they don't know. And it's not that they don't care, but number one, we're at usually the judges are at the very bottom of the ballot. They don't know, they just know I'm voting for judges. And in this case, I'm selecting 4 out of 5 or 4 out of 7 or whatever the case may be. But they don't, when we're on the ballot, we are simply listed alphabetically. And it doesn't say these 4 are current judges and these 3 are challengers. We're just listed alphabetically. So I'm not sure we're doing the public a service in the current process as to whether or who they're voting for that is going to be making decisions about their lives.
And as You may remember, I believe, when we served in the House together, I may have been the co-sponsor on one of your pieces of legislation, and I share with some of my colleagues sitting there and at the time listening to Billy Murphy essentially tear our legislation to pieces.
He was on my work group. I know how to do this. Bring your, people that oppose you, you bring them in.
Right, and so in the back of my mind, what I keep remember him saying was, you don't take away the power that you've given to the people. The people have this power, why would you give it away?
And that's a fair question, and my answer, and again, it's okay to disagree, my answer is, after the academic study of what is the best way to ensure that we have a qualified, independent, impartial bench, my position is that the selection process that is in the report is that process. It is not that I'm trying to, quote, take power from the people. It is I'm trying to make sure that people have the most qualified judges and independent judiciary possible. And I feel better knowing that we have the Judicial Nominating Commission process, that we include more public input and education, and that is the way to make sure that we have the best judiciary.
Thank you very much.
Thank you.
All right, we're going to go on to Senator Henson and then Senator McKay. I just remind the panelists and the members that we are on our first bill and the first panel of the first bill. We have 13 bills to go. Senator Henson and then Senator McKay.
Chairman, reminder heard loud and clear. If someone could follow up, I'm interested in the data surrounding retention elections. How often do people lose retention elections? I think if I could take a look at that number, it might help me have the same confidence in the retention process that some of the panelists have. No need to follow up. If you do, that would be great.
I don't necessarily have specifics, but I'll get something for you. I don't think that it's a high number of people that lose a retention election. To be completely honest, I'm not aware of, certainly in Maryland, of anyone that's lost the retention election. But I will do some additional research and be happy to get it to you.
Thank you, Judge.
Okay.
Thank you, Mr. Chair.
And no, just kidding.
You haven't asked a question yet. Go for it.
Now, my only question is, while I 100% agree with you that the work that the committee and retention of a qualified judge should be what we retain in these elections. However, in the process that we have right now, what is stopping a judge that is up for re-election from articulating that to the public? If the issue is educating the public, then I don't think taking the public out of the process by taking their vote away, it should be more on educating the public why they should retain a said judge. I don't know, anybody?
Thank you for that. I guess what I would say is I think that there's a concern that the public doesn't really get educated very much on judicial races. There's not that much attention that is paid to them, as has been stated. They're on the bottom of the ballot, and so I think that the reality of the election cycle is that there's just not as much information paid to those in order to educate the voters at the end of the day. It's certainly a fair point. I'm just not sure that that's the way it works out in practice.
And I understand that, but that's not the fault of the voter. That's the fault of the person trying to articulate why they're the best candidate for that particular job. And taking away the will of the people, I'm not exactly sure is the way to go. But thank you, sir. Appreciate that.
No further questions from the committee? I'll just say, if this bill gets out, or some iteration of this bill gets out, one of the stumbling blocks of this legislation in the past has been the example that was brought from Senator West, which is from the Monumental Bar Association, and diversity on the bench. That's been the through line. So it gets out on the floor. There are several caucuses that will be very much interested in what the composition of the bench looks like today. you all have submitted testimony that outlines some of the diversity and some of the trend lines from the past couple of years. And I think, Judge DeMay, you're right to speak to the diversity over the last couple administrations in particular. Governor Hogan did a better job than Governor O'Malley did with this, and Governor Moore is on track to do a better job than Governor Hogan did. But just, I would direct the committee's attention toward the judiciary's testimony and the diversity of the bench, not only through the Judicial Nominating Commission, but just what's reflected. So the work group found that Maryland judges are broadly representative of the population of Maryland. As of April 2024, 51% of judges identified as female, 49% as male. Additionally, Black and African Americans judicial representation is 30%, which is consistent with Maryland's most recent census of 29% in the population. So as we move forward and different interest groups converge on this idea, I think we're going to have to flush out some of these issues of not only diversity but qualification and some of the perverse outcomes that are implicated when you have these elections. I can speak to my own example. In 2014 was the first time I had this, standing next to judges during early voting, members of the bar who had matters and would have matters before the very judges that they were voting, they were campaigning for. I'll never get that image out of my head. So I appreciate you all coming today, Your Honors, Chief. Thank you all very much. Thanks. All right, so we'll now move on to the next panel, and is Dean Donald Tobin? Is Dean Tobin here? Yeah. Hey, there you are. And then we'll hear from MSBA, Kelly Hughes Iverson, Mr. Santini, and then we'll have Casey Florence coming up. Actually, these are all virtual. We can put them in. And then is Janelle Ryan Colbert here from the Prince George's County Bar Association. Mr. Jerichow. There you go. So there. We'll do this, and let me see if we get somebody. We'll port them in a second, and then Mr. Wiggins. I saw Grayson Wiggins here. All right, and then after we complete with their in-person testimony, we'll switch over to the virtual panelists.
Thank you, Chairman Smith and members of the committee. I'm thrilled to be here. I do need to note that President Kurt Schmoke from UB was not able to come, but has submitted written testimony and wants, he was also on the commission and wants you to know that he is also in favor. I'm here because having a high caliber independent judiciary is essential for our democracy and for our state, and contested elections, to me, put our judiciary at risk. I was dean of the University of Maryland Francis King Carey School of Law from 2014 to 2022. I'm now a professor there, and one of my specialties is election law. And so I've had a career to look at elections and judicial elections, and having a non-political independent judiciary is essential, and elections really put that at serious risk. So I want to address a couple of the things I heard. One is about the will of the people. The will of the people is incredibly important. It's important for our system to survive, but it is not the way in which we think about an independent judiciary. In another state that has judicial elections, when I was there, I watched judges walk through law firms and ask for money. How can we think as a person appearing before a judge that that judge is independent when part of what that judge has to do is put his or her hand out for judicial contributions? We think about the will of the people, but we don't have elections in any other level except for the circuit court. We have a history and a problem in Maryland of not having a diverse bench. We've been working on that for years. Judicial elections are not the answer for a diverse bench. The answer for a diverse bench is to have diverse candidates who move through the process and are put forward by these nominating commissions. In my testimony, I joked, do we want the Yankees picking the umpires? Of course not. When a citizen comes before a judge, they want an independent voice. They want to know that their case is being heard and that it is not the amount of dollars they've contributed that is at issue. So I'll close, since I think I'm already out of my time, is to say I get calls all the time. Should I vote for this judge? Should I not vote for this judge? What judges should I vote for? There is too much money. There are too many people running for office for a little judge, not size-wise, who has a little bit amount of money to try to get their issues and their voice out there, especially when by judicial ethics, they're restricted from doing so. We need a better system. We have a fabulous judiciary in Maryland, and we need to make sure we keep it so. Thank you very much.
I'll come up next. Members of the Senate Committee, my name is Ronald Jericho. I'm testifying on behalf of both the Maryland Association for Justice and myself. I'm a former circuit court judge in Anne Arundel County. I lost the 2010 election. Please look at my written testimony. I've got charts in there concerning statistics and research I did. For example, in Maryland, in the 1800s, when contested judicial elections were adopted, only 11% of the registered voters voted. Now 49% vote. If you look, I have in there a summary of some counties, get similar statistics, a very small per amount in numbers. In the 1800s, that was 687,000 voters. Now there are over 6 million voters in Maryland. And the gist of that is that the voting public just can't know the judges. I have another chart that I forgot to actually attach, in which I did the 2024 election. You get between 19% and 50% of the voters who vote in the general election who do not vote in the judge election. And that's, again, an indication that they just don't know who to vote for. As has been said before, it's a down-ballot race. In terms of one of the charts I attached, one of the questions, Senator, you asked was about why doesn't the judge go ahead and advertise and get his name out? I did a chart from 2020, which talks about how much money people have to raise. You've got to raise between $200,000 and $400,000 in order to run countywide in the election. It is a huge task. You heard yesterday the testimony from Chief Justice Fader about St. Mary's County being overwhelmed with work there. When you're running as a judge, when I took the bench, I worked day and night to do a good job as a judge. There just isn't time to go out and be a campaign. Every challenger can arrange their life, choose to run. A judge doesn't do that. Please look at the other points in my position papers. It mirrors not what's in the report of the work group, which we wholly endorse, but also other points that I'd like you to consider. Thank you.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. I'm not going to belabor any of the same talking points that you've heard for more than an hour. Just on behalf of the business community and our members, which include businesses and nonprofits that range from Hagerstown to Baltimore City to the Eastern Shore, those magical JPR words, us too. Thank you.
No questions from any members? Yes, sir. Yes, ma'am.
Thank you, Mr. Chairman. I'm sorry, sir, what was your name again?
Jericho, Ronald Jericho.
Thank you for, if you would step up. I didn't ask any questions during the initial panel because I thought great questions were being asked, so I didn't have to add, but I just want to appreciate one of the things I think the committee should hear is some of this history. Because, my family had been involved in the constitutional conventions in the 60s. And this was brought up back then, the idea that we should not have these kind of judicial elections as opposed to retentions. Or get hung now, for sheriffs perhaps should not be running. A lot of things that had come out when the country and the state was small. The voting population was small. I'm not suggesting that was correct, just saying that's the way it was. There was a lot more ability for the community and the candidates to know each other on a very intimate basis, to put it honestly. So the concerns that have come along with modern and ever-increasing elections, many of those things are wonderful, including participation, more participation. But there are then some of these elections that relied very much on you're going to know this particular couple of people, as opposed to maybe they don't need to know us as intimately and others. That has changed, and I think that you're helping us show that those numbers, what was going on, and it goes back even further, is very helpful to people. So I just wanted to thank you for adding that to the to this whole debate.
So in my position paper for the Maryland Association for Justice, I have the chart. I looked at Maryland statewide and looked at 5 separate counties. For example, in Anne Arundel County, 1864, which is the 1867 Constitution of Maryland, is when contested judicial elections were adopted. Now, I've got the citation here where that comes from, a very good article from the University of Baltimore. But in Anne Arundel County, for example, in 1864, there were 1,990 votes cast in the presidential election. There were 311,000 votes cast in the 2024 presidential election. And for judge, when you get down, I have population studies, 8% of the voting population, the registered voters in Anne Arundel County that year voted for judge. In 2024, 53% of the,
right?
yes, it's right in there.
Really good.
And I did it for selected counties. And then I did is I said I forgot to attach this chart, which I can supply to you, which is a chart studying the number of people who voted in the presidential election last year in 2024 and what percentage actually voted for judge. It's a little bit hard because some people only voted for one office. There were 2 contested elections. Of course, one was in Anne Arundel County where the African-American judge lost in a contested election. But what's reflected in this is that last year in Anne Arundel County, if I can find, here it is, there were 306,000 votes cast for president. There were an average of 204,000 votes cast for the 4 candidates for judge, meaning that there was about 30% of the voting population that voted for president that didn't vote for judge.
Right. And that's a good data point, but I think the deeper history, I don't know if I didn't read this yet, probably I hope goes into the fact that when this whole system was created, there was a familiarity between candidates and the voting public in this kind of election and several others that made complete sense that you would rely on familiarity and closeness and community. As we've expanded the franchise, which is a very good thing, we lost the fact that the protection of familiarity then begins to get lost as well, and that we should revisit those elections to say to ourselves, are we still capable of having a quality election where the voting public is very familiar with these essential, nonpartisan, completely merit-based people above political issues, hopefully? Or have we lost that protection in expanding the franchise? And I think your numbers help us to see that that has changed and that we ought to be cognizant of it and consider it. If we're going to make changes, consider what we've lost and what we've gained and maybe modernize how we elect certain.
And I should add, I served in the work group with Judge DeMay and Judge Williams, and the answer, I think, to many of the questions, particularly about the minority selection and representation, is in the answer of the Judicial Nominating Commission being broader, which would then select people that reflect either the political or minority members of the community and nominate those to the judge, to the governor for selection.
Yeah, they step in and help with that familiarity process, not only for diversity, but also for quality, regardless of any other immutable quality you have, trying to ensure the quality and merit of the individual, not a particular ideology.
Right, and as you heard from one of the other judges, I think Judge Rhodes, who testified that they were having a challenger that only had 5 years at the bar, or 5 years of residency, because that's all the Constitution requires.
Yeah.
And so you don't have any of the vetting that goes on, that the both process, the application process, the individual bars interview, the Judicial Nominating Commission, the governor's staff, of who Judge Crooks was a friend of mine who served on the governor's committee, the legal staff vets and the appointment staff vets, and then the governor vets. And so it's a pretty rigorous process to get selected to be appointed as judge.
Thank you, Mr. Chairman.
Professor, question for you. My colleague had talked about breeding the familiarity. And would you mind coming just so that everyone can see you? Do you think that familiarity could be regained if we were to bring, or the courts were to allow cameras into the courtroom so that people could see who these judges were and get their own opinions?
Interesting.
I am smart enough not to step my toe into cameras in the courtroom, but what it does highlight is that voters do not have significant information about judges, and they also don't necessarily have the background to evaluate the quality of the judges or their competency. And I really believe that we have one of the best judiciaries in Maryland, but part of the reason is because we don't have that many contested elections where unqualified people win. And I think we want to keep that high quality standard, but I'll let you all decide about cameras in the courtroom.
Thank you very much. All right, seeing no more questions, I thank you all who have come up, and I would like to invite Ms. Janelle Ryan Colbert. Is she in? All right, not seeing her in, we'll move to our virtual participants. So Kelly Hughes Iverson. Is she on?
Yes, I'm here. Thank you.
All right, you're on.
All right. Thank you very much, Mr. Chairman and distinguished members of the committee. My name is Kelly Hughes Iverson. I am a co-chair of the MSBA Laws Committee, which is an arm of the MSBA that reviews and advocates on bills in our ongoing efforts to advocate for the legal profession, preserve the integrity and the independence of the judicial system, and improve access to justice. Just as an aside, briefly to follow up on what Dean Tobin was saying, I would point out that anecdotally, I also get calls every single election asking, who are these judges and who should I vote for? They don't really want to know about the judges. They just want me to tell them who they should vote for. No one asked me that about delegates or senators, so you can rest assured on that. But the elimination of contested elections is essential to the public trust and judicial independence. Judges must be able to apply the rule of law in an impartial and unbiased manner without a perception of undue or improper influence. When my clients appear before a court, they do not want to know whether the judge is a Democrat or a Republican. They want to know that the judge will be able to evaluate their facts and their situation impartially. But under this current system, the appointed circuit court judges must run in an election within 1 year and engage in fundraising and campaigns and fundraising from the very individuals and attorneys who are appearing in front of them. Elections in this context add to the noise of interest groups and influential voters buying their way into the system, even if it is just an appearance. This appearance of sitting judges accepting campaign donations from the attorneys and litigants who have cases before them undermines the public trust in an independent judiciary. And to address very briefly the issue of diversity and whether that it will be satisfied under the retention election, I would direct the panel's attention to the Supreme Court of Maryland and the diversity that we have received through that appointment system, which would be the same here. Thank you very much, and I would welcome any questions.
Thank you very much. Raphael Santini. You have to take yourself off of mute. Mr. Santini, there you go. There you go. You're muted again, Mr. Santini.
I am apologizing for my incompetence, Chair Smith and Vice Chair Wall Striker, members of the committee. My name is Raphael Santini, and I am the president of the Maryland State Bar. We represent thousands of legal professionals across the state and serve as the voice of the profession. I am testifying today in support of Senate Bill 630. I've been thoroughly enjoyed the conversation that has gone on before my comments, not only as a naturalized citizen, also a practicing attorney for 30 years, and also past member of the Maryland Hispanic Bar. I want to stress 3 points. The circuit court judicial officer is the only one that has to run for election. An administrative judge does not, a district court judge does not, an appellate court judge does not, and a Supreme Court judge does not. A second point is the impropriety of accepting donations across and running for a campaign. Circuit court judge has to go around begging for money, which is ridiculous. Additionally, the contested judicial election is not a true election. A circuit court judge is prevented from speaking out. The loss of respect for the legitimacy of the judiciary is a major concern of mine. When an unvetted person becomes a judge, it causes the loss of respect. We all know what happened in Prince George's County with Judge April Amelie, and we've seen, we would see that in the newspapers, in the Daily Record. Other issue is the issue of judicial security. We all know what happened to Judge Wilkinson in Washington County. Judges do not have security personnel around them, and when judges are around for election, they're in front of the public. Contested judicial election has a chilling effect. It has a chilling effect because people do not want to run for a position where they have given up their prior position, either as a district court judge or had a very lucrative practice, and lose that position. Therefore, they don't have a judge. Judicial elections do reduce diversity, and the examples are Rodney Warren in Anne Arundel County, Judge Jackson Stevenson in Anne Arundel County, Judge Staten in Howard County, and Judge Alexander Wright in Baltimore County. I ask you to support Senate Bill 630. If you have a question, I'm open for it.
Thank you very much. Casey Florence.
Good afternoon, Chairman Smith and committee members. I'm pleased to be here today. I'm coming to you as a member of the Trial Court's Judicial Nominating Commission for District 11 in Montgomery County. I also have 17 years of private practice. I practice family law in circuit courts around the state. I've served on the Bar Association of Montgomery County's Judicial Selections Committee, including as the chair of that group. And I've also served for many years in various roles for many sitting judges' campaigns in Montgomery County. So I wanted to make myself available to answer any questions about any of those various things. Most importantly, I don't want to repeat anything anyone has already said, but to put a really fine point on it, several people have alluded to the fact that once a judge is appointed, then they have to run as a slate. They have to run as the sitting judges. They are out campaigning, but not for themselves independently, not as a politician, but as a sitting judge. That's because they're also going to court every day doing their job as judges in our circuit courts across the state. And they have their own, as we all know, set of rules and guidelines of how they have to comport themselves day in and day out as a judge. And that includes on the campaign trail. I've worked polling places for the last 15 years in all the contested elections that have happened in Montgomery County. The public does not get this. They don't understand it. They just want to be told who to vote for. And the problem is the contenders that I have seen anyway are saying all kinds of insane things. These judges were all appointed by Donald Trump, for example, in the last contested election. And the judges are really hamstrung in what they can do to campaign. So how they campaign, that they've been vetted. They've gone through the Judicial Nominating Commission. They've been vetted by 14 groups across all the specialty bars. And they have to stand on the platform that we created for them to vet them and get them appointed in the first place. And it's a huge disservice to our state that we then force them to run in contested elections.
Thank you very much. Elizabeth Hewlett.
Yes, good afternoon, Chair Smith and members of this esteemed committee. I am Elizabeth Hewlett, a 4.5-decade attorney in Prince George's County, Maryland, and I wholeheartedly support SB 630, which drastically improves the very problematic dual appointment election approach to becoming a judge in Maryland. And for all the reasons already articulated, but my main reason is because of the vetting process. One approach requires extensive vetting to ensure that we get the very best of the best to serve our citizens. The other approach, no vetting or evaluation required. Let's take the judicial appointment process. Applicants complete a 20-plus page application disclosing their professional and their personal details, the good, the bad, the lawsuits filed, the number of jury trials, key cases, opposing counsel, and the references who are then contacted. They are then interviewed by the 14 associations that you heard, state bar association, county, women's trial attorneys, minorities, to be evaluated and viewed extensively. Then there's the next level, the extensive interviewed by the gubernatorial Judicial Nominating Commission, which consists of lay people and attorneys, and they review the recommendations of the bar associations, review only, don't determine, but the references, and they assess the integrity, the work ethic, the timeliness, the ever so critical temperament of these prospective judges, how they treat everyone in the courtroom, not just the litigants, but the parties, the defendants, everyone that comes in, the courtroom personnel, the reputation for fairness and impartiality, and the breadth and experience, public sector, private sector, civil, jury trials, etc. You contrast that with the current approach, which bypasses the vetting. All they need to be is 30 years old, live in Maryland for 5 years, maybe be admitted to the bar, not necessarily practice, pay the filing fee. That's it. There's no vetting. How does that serve Maryland residents? This bill presents the best of the best, the vetting process, plus the retention elections, and I thank you for the opportunity to share my thoughts.
Thank you very much. Timothy Maloney.
Good afternoon, Mr. Chairman. I also rise in support of this legislation for 5 reasons. First of all, I should tell you that I served 16 years in the General Assembly and have been a member of the bar for 38 years. And I have seen profound changes. We now see judges retiring early after they get their 15 years in, even though they had many years of service left because they don't want to face an election. We've lost many highly qualified judges to this. It used to be that lawyers in private practice, after about 25 or 30 years of excellent practice, would seek to become judges. We see this less and less. But the major issue I see deals with diversity and people of color. It is extraordinary to me that in 13 Maryland counties, we have never had an African-American circuit judge in the history of this state. Garrett, Allegheny, Frederick, St. Mary's, Calvert, Worcester, Wycomico, Somerset, Talbot, Dorchester, Caroline, Queen Anne's, and Kent. And a major factor is the judicial election. And until this is changed, you will continue to have a judiciary that has never had a person of color in those jurisdictions. The most dangerous place for incumbent African-American circuit judge is on the ballot. We lost Judge Warren, Judge Staten, Judge Wright twice, and most recently Judge Jackson Stevenson, all highly qualified. And if there's a big concern about who the governor appoints, you can add another layer of protection by putting in a Senate confirmation clause like we have in the district court. Retention elections have worked out very well for the appellate judges and should work out fine here. I want to point out one more thing. The recent removal of a circuit judge in Anne Arundel County was a profound embarrassment to the judiciary, and it should be a profound embarrassment to this General Assembly to be subjecting the citizens of Prince George's County to a profoundly unqualified person. And we're going to see more of that unless the General Assembly acts and acts now.
Thank you very much. Morgan Drayton.
Good afternoon to the chair, vice chair, and members of the committee. My name is Morgan Drayton, Policy and Engagement Manager with Common Cause Maryland, here in support of SB 630, which would move us to retention elections for circuit court judges. I will keep my testimony short since the other witnesses have already said a lot of what I was planning to say. SB 630 will bring the circuit court appointment process in line with the retention election process used for appellate court judges, which ensures that voters will still have their say in the process while eliminating this loophole that allows challengers to evade the vetting process that appointees go through. I'll also say that there needs to be a greater emphasis placed on public education and community outreach about these races, as well as public participation within this process. My written testimony provides an example presented to the work group from Colorado, which, if made available in Maryland, would go a long way towards ensuring that voters are able to make more informed choices and that retention elections are overall more meaningful. And I'll also say that if we don't move towards retention elections, that the legislature should consider expanding local public financing programs to cover circuit court judges so that candidates have alternative options for funding their races. But overall, we are very supportive of this legislation, which would be a step towards standardization of judicial election and the retention process. And for those reasons, we would request a favorable report. Thank you.
Thank you very much. And Amanda LaForge.
Good afternoon. Thank you, Chair and members of the committee. It's my pleasure to be here today. I wish I was with you in person. My name is Amanda LaForge. I'm Chief Counsel to Governor Wes Moore, and it is my privilege as part of my job to assist the governor with fulfilling his constitutional mandate to appoint the judges to Maryland's exceptional judiciary. The governor takes his responsibility incredibly seriously. He thoroughly enjoys the process, and he talks often about how long after he's gone from office and his picture has come down from the walls, those who he has appointed to seats on the bench in Maryland will be his lasting legacy. I want to speak just, and I really appreciate all of the folks who have gone before me. I want to thank the members of our judicial nominating commissions who do an incredible public service by vetting and looking into candidates before they make those recommendations to the governor for him to conduct interviews. The governor has worked very hard to diversify the judicial nominating commissions. He has instituted the first code of conduct for members of the judicial nominating commissions to abide by so that their process is transparent. He is a great, he has been served incredibly well by the work of the judicial nominating commissions who have really put forward exceptional candidates. I think one of the other things that I'd like to speak about, which is something that I hear personally, is that the judicial election system deters qualified candidates from putting their names in to seek appointment to judicial vacancies. Lots of well-qualified lawyers feel that the unpredictability of running is something they're not interested in doing. And I would just finally conclude by saying last session, this body passed the Andrew F. Wilkinson Judicial Security Act. That was a very welcome piece of legislation to protect judges and their families. We unfortunately live in a time where the attacks on the judiciary are increasing. And I think that the campaigning for judges is becoming a much more real concern. So I thank you again for allowing me to appear and appreciate everyone's work on this.
Thank you very much. Any questions from our committee? I do have one question for Mr. Maloney. He's still there?
Yes, I'm right here. Thank you.
All right, you had raised a point about judges retiring early or after their 15-year term because they don't want to run. Do you have any data about that?
If you want, I can send you a long list. What happens is somebody gets appointed in their 40s or late 40s, and then they get into their 60s, and they have a 15-year.
No, I understand all that. I just wanted to know if you had any data that you might be able to provide. This is the first time I've heard that argument.
Oh, I can send you I will make a compilation of the number of judges who have elected not to serve out their full term and serve till 70.
Thank you very much.
Thank you.
Appreciate it. All right. Sure. Next, Miss Janelle Ryan Colbert.
Good afternoon, Mr. Chair and to Vice Chair. My name is Janelle Colbert. My name is Janelle Ryan Colbert, and I am here representing Prince George's County Bar Association. And we submitted a letter, and we are here to express our overwhelming support of this piece of legislation. The Prince George's County Bar Association has three primary reasons that we want to express our support on this bill. First, as I'm sure has already been mentioned, Prince George's County in particular has a long-standing committee with the sole purpose of interviewing candidates for circuit court positions. This vetting process is thorough, fair, and it ensures that the governor can select from a pool of candidates who are not only technically qualified, but who also possess the highest levels of character and integrity necessary to provide over the residents of Prince George's County. Additionally, we believe that eliminating judicial elections will protect qualified judges from being unseated by individuals who may not, in fact, be qualified or certainly have not been vetted to the extent of these judges. Such judges could potentially replace judges who have been deemed qualified not only by our committees, but by peers through various judicial committees who have been established and tasked with this very important responsibility. Finally, we believe that this bill will enhance the safety of our judges serving in this state. We have all seen the disastrous consequences that come when judges are personally targeted by disgruntled litigants. Judges who serve this state deserve to be protected. And we believe that this piece of legislation will improve their safety by reducing risk of harm to judges. Thank you very much.
All right, excellent. That'll conclude the testimony for the proponents of the bill. We'll now move on to the opposition panel, and we'll start off with Robert Daniels, Claudia Barber, and Marilyn Pierre. Is Marilyn here? Marilyn Pierre? Okay. And then Maria Ostreicher. Is Maria here? There you go. All right, excellent.
Chair Smith, committee members, my name is Rob Daniels, and I'm here today in opposition to Senate Bill 630. I'm the current president of the LGBTQ Bar Association of Maryland, and I was a 2024 candidate for judge of the Baltimore County Circuit Court. In its 366-year history, Baltimore County has never had an openly gay person appointed to the bench despite highly qualified candidates having applied. When I applied in November 2024, I received 6 votes from the JNC to proceed. 7 are required. And that's exactly why I took my argument directly to the people, just as the Maryland Constitution permits me to do. The impetus for this bill seems to be the false conclusion by the Judicial Selections Work Group that we've resolved the diversity issue, so popular elections are no longer needed. But the work group has moved the goalposts in the diversity fight by ignoring the dearth of LGBTQ judges in our state. Governor Moore's executive order regarding judicial selection directs that individuals of diverse sexual orientation shall be encouraged to apply, and that the commission shall consider the importance of having a diverse judiciary. But this is not happening in most counties. If LGBTQ people aren't being appointed to judgeships by the most progressive governor this state has ever seen, when will it be? Sometimes it falls to marginalized populations to fight for their own rights in a way that political figures simply cannot or will not. This bill is a rushed effort to soothe a vocal minority in the legal community. The people deserve a comprehensive approach in the judicial selection process, and if it's to be changed, this should not be a piecemeal quick fix. I'm running out of time. Slanderous allegations were made against me in this chamber, and I would appreciate the chance to address them, if I may, for several moments. May I have 40 seconds of the committee's indulgence?
Somewhat of an unusual request. I'm sorry. Just I'd like to keep our testimony captains.
Chair, I understand it's also unusual to be personally called out during a committee meeting and have slanderous allegations made against one. So I'd like to address them.
I'm not aware of such outlet. I'm not sure that
they were made by Speaker James Rhodes, and they were also made by Senator Chris West.
Okay. Well,
if I may just briefly, may I briefly,
sir,
just...
I'm sorry that this is not the forum for that. This is just on this bill, and so unrelated issue. I'd ask you to choose a different forum than this. This is not the appropriate forum. So, thank you very much. Thank you.
Know what gay people, what it means when gay people are called a threat to the community. And we all know that sometimes folks say words that they'd like to say something else, but instead will use euphemisms sometimes to attack someone who tries to make history and bring diversity to a bench that truly has never seen it. So I thank you for the chance to speak.
Excellent. Thank you very much.
Good afternoon. My name is Maria Ostreicher. I am a circuit court judge in Carroll County. I am here in my individual capacity. I'm not a spokesperson for the judiciary. I was elected in November of 2018. I ran against a gubernatorial appointee. I specifically did so because there were many, many, many qualified women that had applied and made the list. I was not one of them, but none was ever appointed. It became the only way to ever see a woman on our circuit court. I remain the only female that has ever been placed on our circuit court. We have still never had an appointed underrepresented party minority member on the Circuit Court of Carroll County. This bill does not do, most respectfully, what the proponents are stating that it does. All it does is remove the power from the people of removing a person that they do not believe is qualified. It does not change the nominating process. It does not require the governor to appoint from the list. It does not require the governor to have a judicial nominating commission. It requires none of those things. Those things were discussed in the work group, but the work group, this bill does not say, please adopt the recommendations of the work group. This bill says, please get rid of elections. That is a huge distinction. All of those other things are currently voluntary. None of them have to happen. The governor could just decide to appoint whoever he wants. And that's fine when the governor is of your same thinking. But when he's not, or she is not, maybe one day, that's not the case. This is not the way to fix the problem that is perceived by the proponents of the bill. I ran in my election at great personal expense to myself, emotional expense, psychological expense, professional expense. I might be doing the same thing testifying here today, but I believe that it is the right thing to do because this is not the proper way to fix the issue of judicial selections. So I had more to say, but I will stop with that. So thank you.
Good afternoon, Senate Judicial Proceedings Committee members. Today, our state legislature seeks to replace the state circuit court's current open judicial election process to a more limited judicial retention process, where voters would not have the same input as voters have now in the current open process. There are many county circuit courts in the state that lack diversity. We just heard the prior speaker, who was a perfect example of Carroll County and her ambitious and brave chance she took to run in an open process, using the open process. Circuit courts that lack diversity include the Circuit Court for Anne Arundel County, which has no Hispanics, no Asian Americans, no Native Americans on its bench, and no African American males. Other circuit courts lacking African-American male judges include Charles County, Montgomery County, Carroll County, and rural counties. The real problem is that the trial court judicial nominating commissions continue to keep it that way by practicing exclusion when it shortlists candidates for the governor to appoint. I urge you to continue to remember this concern, because they would disenfranchise voters if they allowed this piece of legislation to advance forward. It would take the power from the voters to choose their judges and leave it in the hands of the elite and the Judicial Nominating Commission. And as the prior speaker just said, that is not a solution. Since the 2018 appointment of Judge Elizabeth Marsh to the Circuit Court for Anne Arundel County, the Anne Arundel Judicial Nominating continued to practice exclusion in 2019. So this, again, is a concern, and the Senate Bill 630 is not the solution. Thank you very much.
Excellent. Thank you very much. Questions from the committee. Senator Henson.
Thank you, Mr. Chairman.
This is to anybody that wants to respond. Hello, Judge Barber. One of the criticisms that I've heard is that the Judicial Nomination Commission is too political. That if you aren't a member of the right groups, if you haven't formed the right friendships, that even if you are highly qualified, that it can be hard to have your name rise to the surface in a group of folks who really have longstanding relationships. Does anybody, if you've submitted yourself to the process of being vetted, have any take on if it is or if that is or is not a reality?
If I could respond, I applied 4 times. I think a lot of people, I don't have any statistics. I know Mr. Daniels did. I know a lot of people that run apply first. I applied 4 times. Had they appointed a woman, I would not have run. There are not uniform requirements for the judicial nominating commissions. That is one of the things that I was going to discuss. If there was uniformity in the process, in the selection, if one person didn't appoint a majority of the members, if a governor was required to pick from the list, there are many things that would make it a more meritorious process. But I think that it is probably, and I would encourage you to please review my written testimony, but I think that the nominating process is more perfunctory in some places than others. It's probably very effective in some places and maybe less effective in others. So I can't speak for the whole as a group because they're all different and there is no uniformity.
Thank you.
May I? As exhaustive as this report purports to be, and there are recommendations that were made that pertain to the selection of JNC members, this bill extracts one piece of the recommendations and attempts to make drastic changes based upon that one piece. There is a need to reform how persons are selected to the JNC. The report itself says, as noted above, the work group recommends that judicial performance evaluations work in tandem with retention elections so that citizens are educated and familiar with judges who appear on the ballot. The report itself says you've got to do at least these 2 things together. Yet this bill extracts the largest, most major piece that it attempts to take the will of the people away and do that first. It's suspect.
Thank you. Thank you, Mr. Chairman.
Excellent. Thank you.
Just had one.
Actually, all right. I just want to, sir, yes. Please, if you could be succinct, please. Come on up, since Senator Henson. If you could come up to the, ma'am, if you could come to the microphone so we could hear you, please.
Briefly, my experience with the judicial nominating commissions, yes, does point to political matters involving the choices that are come out of the judicial nominating commissions. Sometimes it's based on whether the person has a law practice in Anne Arundel County or whether or not they have connections with certain groups in the bar associations. So yes, it is driven in that way, and it's really not based on the best qualified. Thank you. A law practice in Anne Arundel County or...
Reverend, if you could, if you're streaming the committee hearing on your YouTube, if you could close that tab before chiming in, then it'll prevent the feedback. Okay, Reverend, you're up. Take you off of mute here. All right.
Can you hear me clearly, sir?
Yes, we can. Welcome.
Thank you very much. I appreciate it. Thank you for the time, sir. You never get rid of the will of the people in a democracy when you have a problem you're trying to fix. There's a long history in the state of Maryland concerning judicial appointments that are racially exclusionary, devaluing of merit, and taxation without representation. Maryland is one of the top 4 states in this country in terms of diversity at about 48%. But when you go to the bench and you exclude PG County and Baltimore City, we have diversity of about 9–10%. Another thing, I heard some of the judges say this over and over and over, and I want to address that. Sir, you do not insult the electorate. implying that they don't have the competence to do some research on judges who are running. This is a democracy. I ran and spent almost $20,000 of my own money, didn't come anywhere near winning, but I swallowed that, sir, in a democracy and went back into the drawing board to see if I want to spend money and run again. This type of insulting of the electorate is just unacceptable. Finally, sir, this talk about the election process is corrupting. There's nothing corrupting about an electorate process. For people of integrity, sir, if you don't have the integrity to not be corrupted by the electorate process, I maintain you're not qualified to be a judge anyway. One last thing, sir, is when you start talking about merit, I hear a lot of talk about merit. We want to make sure these people are qualified. Why in the world we focused on merit? Objective merit has never governed the Judicial Nominating Commission. The last time I was before them, I explained to them that you have recommended people to the governor, put them on the bench. I'm talking about since 2014 when I first started applying. Even though they've been in practice for about 2 years in 2 or 3 different areas, and Reverend Jones has been in practice now approaching 40 years, 18 different areas of the law, and I couldn't even get a recommendation. You never, sir, trash the will of the people to vote trying to fix something that's broke. Thank you very much for the time, sir.
Excellent. Thank you very much. Questions from the committee? All right. Thank you very much. That's it. All right. With that, that'll conclude the testimony and the hearing for Senate Bill 630. We'll now move on to our second bill of the day, Senate Bill 629.
Chair Smith, members of the committee, I think this one will be a little bit quicker, hopefully. This bill is part of the judiciary's continuing effort to enhance public trust, confidence, and engagement with the people of Maryland. We aim to demystify the judicial process and help the public understand what we do and why we do it. Traditionally, both appellate courts in this state have sat only in Annapolis. The one exception for years has been the Appellate Court of Maryland, which is the Chief Judge of the Appellate Court, Gregory Wells, is here next to me, that the Appellate Court of Maryland has sat once a year at each of the state's law schools. By statute, that court is limited to sitting only in Annapolis or at one of those 2 law schools. 2 years ago, having heard of some state Supreme Courts in other states occasionally sitting in their communities, I brought the idea back to the members of my court, all of whom readily embraced the concept. In November of 2023, we sat at a high school in Prince George's County for our oral arguments. We believe it was the first time since 1851 that our court has sat anywhere outside of Annapolis. We resolved to sit twice a year in a secondary or post-secondary institution, educational institution in the state of Maryland. We sat at the College of St. Mary's in St. Mary's County in May of 2024, then in a high school in Baltimore City last October, and we will sit next month at Montgomery College in Montgomery County. Each time we sit, we invite local high schools from the area to send students, hold question and answer sessions with students after arguments, and then hold a lunch with the members of the court and a group of students of that school. Each occasion has been very special for us, and we believe for those communities. The effort has been so successful that we're looking to expand it to the Appellate Court of Maryland. Because of the statutory restriction on where that court can sit, we need your approval to make that change. It will allow the judiciary to further engage with the communities we serve in promotion of our efforts to enhance public trust and confidence in the judiciary and educate the public about government in general and the courts specifically. I look forward to your questions, and thank you for your consideration, and I'll turn it over to Chief Judge Wells.
Mr. Chairman and members of the committee, my name is Gregory Wells, and I am the Chief Judge of the Appellate Court of Maryland. I'm here asking for your support of Senate Bill 629, which will allow my court to sit outside of Annapolis at high schools and post-secondary institutions of higher learning throughout the state. My court consists of 15 judges, men and women from different backgrounds and points of view, various ethnicities from every corner of this great state, and we meet in Annapolis working together as a team for the cause of justice. I ask you to support the bill because it will allow more of our citizens, particularly our young people, the next generation, to see our judges in person and to understand how we do our job of interpreting the law. We work to resolve disputes fairly and peacefully. By taking the court outside of Annapolis, we hope to inspire our fellow citizens to take a closer look at how we resolve disputes in an orderly and respectful manner. Appellate advocacy is chiefly about making an effective argument. By witnessing in-person oral arguments, citizens will see us as we ask tough questions about how the law should be interpreted and watch litigants respond to those questions. They will observe firsthand how we work through difficult legal questions about what the law means. We believe understanding how my court works will have a profoundly positive effect on our citizens. We deal with questions about criminal law, family law, employment cases, as well as business disputes, just to cite a few examples. In fact, there is no area of everyday life that our court will not address at some time or another. And significantly, our court is where many disputes end in the judicial process. Holding hearings outside of Annapolis is designed to promote transparency. Everyone knows we rely on the media to report on our government and hold it accountable, but there's no substitute for personally seeing the process in action, and this bill will help the public do that. Thank you, Mr. Chairman and members of the committee.
I'm not sure about your law school education, but I understand you are the recipient of a fine education from the Sterling Institution for your undergraduate institution.
That is correct.
Yes, you're right, William Mary. UVA is okay too, but yeah. All right, questions from the committee? All right, thank you both very much. Thank you.
Thank you very much.
All right, with that, that'll conclude the hearing for Senate Bill 629. We'll now move on to Senate Bill 621.
That's why I stayed in my seat, to see if that was next. Mr. Chairman, members of the committee, thank you very much for considering Senate Bill 621. I want to open by expressing appreciation for your support last year for the Judge Andrew F. Wilkinson Judicial Security Act. Enacted in the wake of the assassination of Judge Wilkinson, the law has made a big difference. In light of national trends pointing toward continuing challenges to the rule of law, these protections are of increasing importance. One component of the Wilkinson bill brings us back here today. The law created a task force to study this, a task force to ensure the safety of judicial facilities. The task force's challenge was to address 3 different areas to identify minimally acceptable security standards in those areas. As relevant to the bill we're here for today, one of those areas was security personnel in courtrooms. This is an issue of critical safety, not just for judges, but for every single person who enters a judicial facility. Shortly after Judge Wilkinson's assassination, I was looking for information to provide judges around the state of Maryland to provide them information about their personal safety. One of the first things I was given was this pamphlet from the National Center for State Courts. The first page of real substance is page 2 of the pamphlet, which applies in the courtroom. The first bullet point on that page is, do not conduct court sessions or hearings in the absence of a court security officer. Information provided nationally to judges around the country. That is, in fact, the correct standard. If we followed that in Maryland right now, we would have a lot of dark courtrooms. Across the circuit courts, especially in our largest jurisdictions, there are more courtrooms in family and other civil cases without court security officers present than with them. And that's really important because family cases in particular are among the highest conflict cases we see. It was a family case that led to Judge Wilkinson's assassination. The task force identified a minimum acceptable standard for security personnel in courtrooms of at least 1 qualified court security officer in every courtroom, and a second in every proceeding involving an incarcerated individual or somebody who might be incarcerated as a result of that proceeding, as well as others able to be called upon if there's reason to expect extra help is necessary in a particular proceeding. This bill, Senate Bill 621, has 2 primary purposes. The first is to establish that minimum acceptable security standard in law. The second is to collect information to help figure out exactly what the gap is now between the identified minimum acceptable standard and what is in place now across the state. There are some jurisdictions, some circuit courts, that are meeting that standards. We believe that most are not. For that purpose, the bill requires the collection of information from each of the 26 different entities responsible for providing security at courthouses throughout the state. We anticipate that information helping to inform a legislative proposal next year about how exactly to implement and fund that minimum acceptable standard. I do want to end by expressing deep appreciation for the work put in by all members of that task force. I look forward to your questions and thank you for your consideration. And I'll turn it now over to Judge Audrey Carrion, the administrative judge for the Circuit Court for Baltimore City.
Thank you, Chief Justice. Good afternoon, Mr. Chair, members of the committee.
I'm here today to emphasize the critical need for enhanced security measures within our courthouses. The presence of dedicated court security officers in each courtroom, as well as additional court security officers for individuals who are currently incarcerated or who may be remanded, is not just a matter of policy. It is necessary for the safety of all who participate in our judicial system. Courtrooms are environments where emotions run high. Judges, magistrates, attorneys, witnesses, members of the public regularly encounter individuals who may be expressing extreme stress, anger, mental health issues, and desperation. Without consistent security presence, the risk of violent outbursts and disruptions increases, placing everyone at risk. Dedicated court security officers in each courtroom ensures that proceedings can be conducted in an orderly and safe manner. Currently, in Baltimore City, we have 34 positions. 16 of those positions remain unfilled due to the fact that salary range is significantly lower than those for other enforcement organizations. The disparity in compensation has made it increasingly difficult to attract and retain qualified personnel, placing additional strain on the existing workforce of the Office of the Sheriff and potentially compromising the safety and efficiency of our courts. In our court, the Circuit Court for Baltimore City, in the last year alone, we've had the portrait of one of our judges removed from a public hallway in the courthouse and destroyed by a probationer to that judge. We've had reports in a federal wiretap regarding plans to kill one of our judges. We've had harassing emails to judicial officers, defacing signs in a public bathroom with profanity towards a judge, family brawls in public areas, harassment of employees in the clerk's office. This past year, as administrative judge, I've had to issue 3 escort orders involving 3 separate individuals to limit their movements of them within our courthouses. I urge you to support this bill, which recognizes the necessity of these security enhancements. A secure courtroom is fundamental to a fair and effective judicial process, and these measures will ensure that justice is served without unnecessary threats of harm. Thank you.
Mr. Chair, Mr. Vice Chair, honored members of the Senate Judicial Proceedings Committee, and of course, old friends. My name is Brett Wilson. I'm the administrative judge for the Circuit Court for Washington County, and I was Judge Wilkinson's supervisor, friend, and colleague when he was gunned down in his driveway. Immediately following this horrific act, Chief Justice Vader began by appointing and creating a task force within the judiciary to do a security review of the entire state system. I was fortunate enough to be the chair of that committee. We had an incredible team that put together 150-point surveys of all judicial buildings and also looked into the processes for security within. This was all made and done to prepare us for the legislative committee that you all helped to pass, creating the task force from which this bill derives. I was fortunate enough to serve as the Standards Work Group Committee Chair, and I want to give you some background on where this bill comes from so you know it is not something that was simply developed, but is based on research and experience. The Standards Work Group was assigned specifically to look at both processes as well as physical features that could improve security throughout the judicial system. In order to do so, we looked at the National Center for State Courts Steps to Best Practices for Court Building Security, a document which had been over a decade in the making. National Security for State Courts, National Center for State Courts, founded in 1971, a nonprofit focused on improving court administration and efficiency worldwide. The Arizona Judicial Administration Court Security Standards, which have been put in place by executive order in 2015, and did a top-to-bottom review of their judicial branch to ensure court security throughout the system. The Georgia standards for courthouse security created by a standing committee on judicial security, which was put in place after the horrendous 2005 escape and murder inside a Fulton County courthouse, where a defendant was able to overcome his single security officer, kill the judge, the court reporter, a deputy while escaping, and a federal agent on the outside. Many of the standards that you see here are derived from what they found through experience in the worst way. We also looked at the CALEA standards for court security. If you don't know, the CALEA is the Commission on Accreditation for Law Enforcement Agencies. It sets up rigorous standards both for accreditation of law enforcement agencies as well as doing well-researched findings and recommendations for court security, as that is part of their task. This bill will help to ensure that all persons in a courtroom will be kept safe pursuant to the best practices available nationally. It is based on the findings from extensive research and tragic experience. I hope that you will support this bill, and I will certainly answer any questions at the appropriate time.
Good afternoon, Chairman Smith, Vice Chair Wallstreicher, members of the committee. My name is John Morrissey, and I'm the Chief Judge of the District Court of Maryland. The security needs of each courthouse to protect not just the judges, but the clerks that work there and the public that come to the courthouses remains the most critical issue for all 33 of the courthouses that comprise the district court system. Last year, the district court saw more than 2.5 million visitors. The bailiffs of the district court, to whom I and the public owe a great deal of appreciation, confiscated over 70 firearms, over 8,000 knives or razors, almost 4,000 chemical sprays, and more than 1,500 tools. A quick example of some of the actual cases in the last 6 months may highlight the security needs. On September 20th of 2024, at the Glen Burnie District Court, an individual attempted to bring in a double-barreled .38 Derringer, one of those little guns, with 7 rounds in a metal tin. It was detected at the magnometer. The suspect was there to attend a temporary protective order hearing, right? That's a great concern. On September 26th, less than a week later, at the Hagerstown District Court, an alert bailiff noticed a fully loaded 9mm Smith & Wesson in a bag that went through the metal detector. On October 21st, at the Catonsville District Court, a .43 Glock handgun with 10 rounds in the magazine that was wrapped in aluminum foil and duct taped to the suspect's groin area was discovered when the bailiff screened the defendant at the door. During the interview, the suspect indicated he wrapped the gun in foil in hopes it would prevent detection. On December 5th, an individual coming to meet parole and probation, they were already on parole or probation, was detected with a loaded semi-automatic handgun. Finally, on January 31st, 13 days ago, and you probably saw this in the news, an individual with no business at all before the court, they did not have a pending case, they had no contact with the court, entered the vestibule area of the East Side District Court in Baltimore City and committed suicide in the presence of multiple members of my staff, of multiple members of the public. We're still struggling with that right now, and my emotion comes to my voice as to what all those people that witnessed that saw, and for the individual that committed suicide. The bailiffs involved, in my opinion, saved countless lives and are true heroes. Members of the committee, we need your help. On behalf of the 124 judges, the 300-plus bailiffs, the district court commissioners, and over the 1,500 staff members and the over 2.5 million visitors that come to the court each year, I urge you to give this bill a favorable support. Thank you.
Thank you very much. And this is for any of you. In looking at the written testimony, you have, what looks to me is there's a division on how sheriffs of certain jurisdiction look at this. Baltimore City Sheriff, he's supportive. I believe the sheriff from Talbot is in opposition. the chiefs and sheriffs, they've provided information, and MACO has testified has provided written testimony favorable with amendments. I think the through line with most of those, except for the outside of the ones, Baltimore City, is cost and where the cost is going to come from. I think one piece of testimony characterized this as an unfunded mandate. Would you all mind speaking to this, given where the state is with this fiscal situation?
So one of the issues that we confronted in the task force was a lack of sufficient information, frankly, about exactly where we were. We were operating on a pretty quick time frame because we wanted to be able to present something this legislative session, so a report was due December 31st of this year. We attempted to get precise information, but it was complicated by a number of factors, including differing definitions of what a court security officer is and what could meet that standard, different understandings of who was providing security, where, and of how many positions were open but unfilled, as opposed to positions that might be necessary to meet the standard that weren't allocated at all. And at the end of the day, the task force did two things. One is the task force's recommendation for funding, without respect to what the number is to get to that level, was basically to have a state support for the localities to get up to the minimum acceptable standards over the course of a 5-year period of time, starting in fiscal 2027, that would have an initial allocation that would be 80% of whatever the difference was between what's currently being met and what's needed, diminishing by 20% a year over time, so that the state, right now at the circuit court level, this is a local funding obligation, and the idea was that there would need to be, or that would be appropriate to have some state funding to transition until the local governments were able to adjust and carry that burden. But we weren't able to assign a specific number because of the deficiencies in the information that was available, and so that's the second part of this bill, which is a very important part, which assigns to the 26 jurisdictions, which are 24 sheriff's offices. With respect to the district court, it's the district court itself, which hires bailiffs to provide security. And with respect to the 2 appellate courts, it's the administrative office of the courts that has a security division. So for each of them to basically work to do the assessment, to figure out exactly where we are, where the deficiencies are in being able to meet that standard, put together a plan to get there, identify the challenges to meeting that, so that we can come back then next year with full information about the costs involved and put together a plan to meet it. That plan from the task force was what I described, that diminishing state support for the localities to be able to get to that, but without sufficient information about what exactly the deficiencies are now and what exactly those costs are, we didn't feel like we could put that specific formula in.
Thank you. And just to make certain I understood what you said, sheriffs, they provide security at district and the 24 circuits?
The sheriffs provide it at all 24 circuit courts. At the district court, which is a single unified court, the district court has its own security through district court bailiffs. Okay. So that is funded by the state through the district court's budget.
Gotcha.
And the district court now, not without great difficulty, the district court now is actually meeting the standard that we have in here. And in fact, the more national best practice in most cases, which is actually having 2 court security officers in every courtroom. But they still need to be covered by the standard. But the security at the district court level and for both appellate courts is funded by the state through the judiciary's budget. The funding at every single circuit court is the security is provided by the sheriff and funded by the local legislative body.
Thank you, Mr. Chair. Mr. Chief Justice, thank you for presenting this bill. Under normal circumstances, I would be 100% supportive, without exception. The problem is we have a serious financial problem. I like the second half of the bill, which requires that a lot of information be assembled and provided along with a plan, a viable plan to meet the minimum adequate safety standards under Section 1 of the Act. And I assume the deadline for that is the end of the year?
It would be end of September, I believe, in order to provide a sufficient amount of time to analyze the data and propose something based on it.
Year. I also like your recommended way of phasing it in. Makes a lot of sense. The first part of the bill, however, seems to implement the plan starting July 1st, 2026. And my question is, isn't that a little bit putting the cart before the horse? Shouldn't we come up with the data first and the plan first before we import into the law specific requirements?
So I have two ways of responding to that. One is that it is really critical that we meet this standard. It's critical for the safety of everybody who enters our judicial facilities, and we're not coming in asking for what really is national best practice, which is 2 security officers in every courtroom. We're asking for what we think is a reasonable, minimal, acceptable standard. And so, without regard to where the funding comes from, we think that that this standard needs to be met.
But here's the thing: in the first part of the bill, nothing has to happen until July 1st, 2026, which is close to a year and a half from now. Wouldn't it be better to get all the data later this summer and then for the General Assembly next year to pass, maybe on an emergency basis, the first part of the bill, if that's the decision we decide to go down based on the funding information?
Well, and that gets to what I was going to say is the second part of my answer to your question, which is I definitely understand that that concern. And if the decision that this body makes is to have the standard as an aspirational standard or the standard as something that is there for the basis for collecting that information, I certainly understand that and certainly would not say that that's an unreasonable approach. But I think that however we get there, it is really critical to have this standard apply so that every courtroom where these emotional issues are played out has security.
And I agree with you 100% about that. We have to do it. The big question is, how are we going to pay for it? Who's going to pay for it?
I understand entirely.
Thanks.
All right, further questions from the committee? All right, excellent. Thank you all very much. Thank you. Do you have virtual? Okay. Sheriff, actually, would come on up. Yep. And then we've got 2 people joining us virtually.
So I want to thank you for letting me testify here today on this very important bill. I want to thank the chair and everyone who's listening. So this bill is incredibly important for me as the sheriff of Baltimore City, who has to provide security in the courthouse, but the local government hasn't funded me to do so. And so, you know, we really get down to that, right? We get down to, should there be a standard that's across the state that says when a judge takes a bench, there should be somebody providing them security? And I think that's an obvious answer is yes. We have to have that, right? We have to. But if you look at my situation in Baltimore City, I'm not funded to do that. And it's unfortunate. And I don't blame the executive branch of government in Baltimore City for it, because this is a long-standing problem that hasn't really been addressed. But if we look at all the sheriff's offices in the state, we see, like at circuit court, there's court security disparities in what should be there as opposed to what there is there, and it all is related directly to funding. And it's whether the county executive or the mayor, right, is willing to put money into a sheriff's office, an independent office that they don't control, to provide security for judges. And I'm here to say they absolutely need to do that, right? We have to have that. And so I'm imploring you in the state legislature to look at these standards and say that it's a no-brainer that we have to have a court security officer in with the judge. And in order to do that, we have to make the sheriff's office have the ability to do that. Because we can't do things that we're not funded for. And so I just need to stress that. In Baltimore City, I want to do everything my administrative judge who's here today wants me to do. I want to provide all the security I can. When they're threatened, I want to be able to do 24-hour security on their homes. I want to be able to conduct a criminal investigation. I want to be able to do everything I can do to keep them safe. And again, I'm here today to I don't want to use the word beg, but implore you to look at this and try to pass this. Thank you. I can take any questions.
Questions for the sheriff? All right. Thank you very much. Thank you.
Thank you.
All right, we're joined virtually by Mr. Deloach. Is Mr. Deloach still in the room?
I'm here, Mr. Chair.
Hey, welcome. Good to see you.
Thank you. Good to see you. Good afternoon, Chair Smith, Vice Chair Wallstreicher, and members of the committee. My name is Jason Deloach, and I'm the immediate past president of the Maryland State Bar Association, where we focus on protecting the legal profession. I'm testifying today in strong support of Senate Bill 621. I came before you last year requesting passage of the Judicial Security Act in honor of Judge Wilkinson. I thank you for unanimously passing the bill to protect the privacy of judges and their families, and for your support as MSBA has continued working with the Maryland Judiciary and partners in the legislatively created task force. MSBA President Santini has been able to share experiences of our members and think through the long-term solutions to provide appropriate security across the state. Today, we ask you to support minimum security standards for all courts across the state, specifically security staffing for courtrooms. As we have shared, our member judges and attorneys involved in high conflict matters, including family, juvenile, and criminal law cases, are at great risk of physical harm and threats and have reported feeling unsafe due to their cases. We regularly hear from attorneys who report a lack of any security presence in their courtrooms, where case facts indicate abuse and violence between litigants. Senate Bill 621 would first provide additional minimum security to those high conflict courtrooms, and then expand over 2 years to provide additional minimum standards for all court proceedings. We support this graduated approach. Given the impact this may have on local counties and funding, we ask for continued input from these partners in the future to best implement these standards. Judges and attorneys must be able to decide and present cases without fear for their safety or for their family. MSBA urges a favorable report on Senate Bill 621. And I would also like to add that I am a judge on the Orphans Court for Prince George's County, and we're lucky to have a sheriff for presence in our courtroom during all proceedings. And the one thing I want to point out, the judges are focused on the litigants. Many times the sheriff will see something in the gallery where she or he may deem appropriate for them to go and handle, and they will get up and do it. So a lot of times judges are unaware of what's going on in their courtroom. So we ask you to support Senate Bill 621. Thank you very much.
Excellent. Thank you very much, Mr. Deloach. Questions from the committee? All right. Seeing none, thank you very much. That'll conclude the hearing for Senate Bill 621. We'll now move on to Senate Bill 619.
Good afternoon, everyone. Chairman Smith, Vice Chair Wallstreicher, members of the Judicial Proceedings Committee. I'm Ann Albright. I'm an appellate court judge, Appellate Court of Maryland. But today I'm here in my capacity as chair of Maryland's Commission on Judicial Disabilities. That is the entity that is charged with investigating and making factual findings regarding allegations of misconduct, disability, and impairment against Maryland's judiciary branch judges. Thank you for the opportunity to testify in support of Senate Bill 619. Today, of course, we request a favorable report from the committee. Senate Bill 619 seeks to amend the Maryland Constitution, specifically Article 4, Section 4A and 4B, as a way of improving the functioning of the commission by allowing the chair of the commission to temporarily fill vacant seats on the commission when necessary. To fill these temporary vacancies, the proposed bill would give the chair the power to either temporarily appoint former members, or to request the governor to appoint temporary substitute members, or to temporarily extend the term of existing members. One of the major constitutional functions of the commission is to conduct public hearings when charges are filed against a Maryland judge. The commission is composed of 11 members, judges, attorneys, and public members who are appointed by the governor by and with the consent of the Senate. It is of the utmost importance that as many members of the commission as possible, but certainly no fewer than a quorum is 6, be present to review the evidence, participate in deliberations, so that the commission's findings can then be submitted to the Supreme Court of Maryland. At times, due to conflicts of interest, scheduling, or the end of a member's term, certain members may be unavailable for the duration of a public hearing. During these times, to ensure that there is a quorum and to conduct a fair hearing, the commission would like the chair to have the authority to appoint a past commission member to sit on the commission for a specified hearing or a period of time. The past member would have been previously vetted by the governor and approved by the Senate. If the chair is unable to secure a former member, the commission chair could then request the current governor to expeditiously make a temporary appointment for a specified time, a specified purpose, or extend the term of an existing member. I respectfully request that the committee issue a favorable report on Senate Bill 619. I am joined today by Kendra Jolivet, who is the Executive Counsel of the Commission. She and I are available for any questions. Thank you very much for your consideration.
Excellent. Thank you very much. Judge, questions from the committee? All right, seeing none. Thank you both very much. Thank you.
Thank you very much.
All right, with that, that'll conclude the hearing for Senate Bill 619. We'll now move on to Senate Bill 622.
Good afternoon, Chairman Smith and members of the committee. My name is Gregory Hilton. I'm the clerk of the Supreme Court of Maryland. I have a different role also, which is at the State Reporter of Decisions that the court appointed me when I was appointed in 2022. I rise to recommend the adoption of slight modifications to Section 13203 of the Courts and Judicial Proceedings article to remove what is arguably some anachronistic language, specifically in subsection B. There's some gender language which has existed in the statute for many years, well over 100 years, as well as to remove a requirement that the office secure a copyright for the state of Maryland as to judicial opinions of the court. There's 2 reasons for that. One is that the second part has become anachronistic because to secure a copyright requires no action by my office to do that under the Berne Convention, which was adopted by the United States in 1988. And secondly, it's arguable that the opinions of the court cannot be fully copyrighted and enforced because they are public statements of law issued by the court. What was largely copyrighted in the past was editorial comments and additions to the opinions that were published in the reports by the Reporter of Decisions. Since about 1983, that has been done by West Publishing, the current publisher of the Maryland reports, and would likely be done by any future publisher as well. So with that, I ask the court to adopt the changes to Section 13203 of the Court's Judicial Proceedings article. Thank you.
Excellent. Thank you very much. Questions from the committee? All right. I think so. Cool. All right, with that, that'll conclude the hearing for Senate Bill 622. We'll now move on to Senate Bill 604. Senator Wallstreicher. Actually, all right. Yeah. All right. Actually, we'll go to Senate Bill 585, and then we're going to, which will take very little time, and then we'll move over to Senate Bill 604.
Thank you, Mr. Chairman. Senate Bill 585 is a quick fix. 2 years ago, we passed a bill. This was intended to be in that bill, but we thought it might be included already in federal law. Last year, when we realized it was not, we passed it in an amendment form unanimously. It got stuck on the House side on signing day, so I just asked for a favorable report on Senate Bill 585.
Excellent. Thank you very much. That'll end the hearing for Senate Bill 585. Oh, sorry. Apologies. So Senator Love.
Since I wasn't here last year and I didn't hear it in ENT, this is all new for me. My understanding on the legislation that we passed 2 years ago was that that someone could not enter property without express permission to come on with, basically you couldn't carry a concealed weapon onto someone's property. Is that correct?
So, no, that portion was struck down by the court. And so the way the law works is that unless there is notice otherwise, and there is notice, as you know, on this building, on many other buildings, that unless there is notice otherwise or you're specifically told otherwise, you can bring your firearm onto private property.
So then why do we need this?
Oh, this is specific to a certain class of people who are otherwise trained and badged. We thought they were covered by a federal law called LEOSA, and therefore we thought it was included. It was always intended to be included. When we realized that we were incorrect in our assessment, we brought it back last year and passed it.
I'm sorry, I'm not following. If anyone can bring in a concealed firearm to someone else's property, why do they need express authorization to bring a concealed firearm onto someone's property?
Sure, because law enforcement is treated differently under the law, is the short answer.
But they're not law enforcement anymore. They're retired.
Correct, but they receive certain rights under LEOSA, the federal law that governs how firearms are treated for law enforcement, for former law enforcement. And by having those special treatments, we want to make sure that that law, that federal law, is respected in Maryland. We thought the federal law alone was sufficient, and when we realized that it would be advantageous to instead repeat it here, we went back to include it. It was always originally designed to be part of the bill.
Okay, I don't mean to belabor the process, Mr. Chair. Perhaps you and I can talk offline because it's still not making sense to me. If anybody can bring in firearms into my home, then why does somebody need special permission to be able to bring in firearms to my home? But we can talk more
Happy to,
offline.
yeah.
Thank
Absolutely.
Okay, so that'll conclude the hearing for Senate Bill 585. We'll now move on to Senate Bill 604. Senator Reedy, is Senator Reedy here? There you are, come on up. Senator Vice Chair Wallstreicher and Senator Reedy.
Thank you, Mr. Chairman. Changing gears here. Today we are here for Victoria, Scotty, Ashley, and Yardair's law. All four were killed by lethal doses of fentanyl sold by local drug dealers. You'll hear from Scotty's dad today as well as Ashley's mom. But first I wanted to talk about what fentanyl is, what problem this bill is solving, and talk about some of the opposition you might hear today. Fentanyl isn't just another opioid. It's one of the strongest poisons you've ever seen. And now on the street, it's in every drug. So how did this happen? So during the opioid crisis of the 2010s, pill mills sold real pharmaceuticals that folks became addicted to. When the government cracked down on both the doctors and manufacturers like Purdue, which is the Sacklers, those who were addicted turned to the street and dealers moved to fill the void. The demand was high, but the supply was a challenge. Making opioids the old-fashioned way, illegal opioids, is really difficult and messy and violent and labor-intensive. You need fields in rural areas to grow poppies, expertise to process plant material into drugs, muscle to protect the product, and smugglers to move it across borders. All of this is very expensive and very violent. Cartels are businesses first and foremost. And they ask, what if we didn't have to grow this product at all? What if there was some way to just make it in a lab for dirt cheap? What if we didn't even need to make it at all, but someone would make it for us, and we'd simply mix it together and move it across the border? What if it was super concentrated, so moving higher doses in smaller containers was much easier? That's how we got the fentanyl crisis. It's made in labs in China for pennies. It's shipped to Mexico to the cartels. It's hyper-concentrated for ease of transport. They move it across the border, no plants, less muscle, less violence, and higher profit margins. And so if someone goes to buy fake Adderall from a dealer, it has fentanyl in it. Why? Because fentanyl is dirt cheap. If someone buys fake perks from a dealer, it has fentanyl because it's cheap. If a dealer says he's selling the purest heroin on the planet, it will have fentanyl in it. Why? Because it's cheap. And that's how we got here. And so now there is no dealer in the state who doesn't know that the entirety of their product, whatever they call it, contains fentanyl. And there's no dealer in the state that doesn't know that this hyper-concentrated poison will eventually kill one of their customers. Now we come to the problem. It is not illegal in Maryland to sell fentanyl that causes the death of another. It's not. And the parents of Scotty, Victoria, Ashley, and Yardare found that out the hard way in the worst moment of their lives. Let me tell you how prosecutors do this today. When there's a death, they always charge distribution. But of course, for parents, this is utterly incomplete. Distribution doesn't acknowledge the death of their children or hold the dealer accountable for that death. Prosecutors sometimes charge reckless endangerment. Reckless endangerment is a 5-year misdemeanor. How does this play out in the real world? Well, Victoria's murderer was charged under that statute. Victoria died from poison fentanyl sold to her, and what did her killer get? Convicted of reckless endangerment, he got 18 months home detention. He lives in Carroll County. Folks see him out and about, living his life. Prosecutors can try manslaughter, but rarely do. The elements don't line up well. It always litigates. We know of only one case of this happening recently, and it was in Montgomery County, and the fact pattern was highly specific. It was a dentist with existing prescription privileges who slowly poisoned his girlfriend over time. The manslaughter statute was not built for drug dealers. And so we need something, a statute specific to this fact pattern that recognizes the bad act at play here and holds those bad actors accountable for that specific behavior. Now, this isn't novel or new or weird. In fact, there was a time exactly like the one we're in a number of decades ago, and it's exactly on point. Years ago, if someone knowingly got drunk, completely blitzed out of their mind, and purposely got into a car to drive, and then killed someone, there was no specific charge for that behavior. Prosecutors tried manslaughter. Sometimes it worked. Usually it didn't. And so the General Assembly carved out vehicular manslaughter, its own statute. The idea wasn't to be harsh. It wasn't a call for blood. It's much more simple than that. We needed a specific statute to deal with a specific issue. And it's the same thing here. We need a specific statute to deal with this specific issue. Now, let me address some of the opposition you're about to hear point by point. First, opponents will claim that this bill targets drug users and not drug dealers. That's false. In fact, the very first line of the bill makes explicit that only dealers are included. Sharing drugs is specifically excluded. When opponents make such claims, I urge everyone to remember something obvious, but it's worth repeating. We don't legislate in ideas, we legislate in text. At my request, lines 22 through 24 on page 1 and line 1 on page 2 were purposefully added to ensure that mere sharing does not come under the purview of the bill. Second, opponents will claim that this bill abrogates our existing Good Samaritan law. This is also false. There's no wording in the bill designed to remove our Good Samaritan drug laws. In fact, quite the opposite. Again, we don't legislate in ideas, we legislate in text. On page 3, lines 31 through 34, and on page 4, lines 1 through 3, we actually repeat the Good Samaritan law in the bill. So why have it twice in our code? Because we want it to be 100% unambiguous as to our intent. The Good Samaritan drug laws are current law, and we consciously reaffirm that in the bill before you. Third, opponents want to create a false choice, that it's either or, that we can have accountability or drug treatment, but not both, that we can have accountability or mental health treatment, but not both, that we can have accountability or harm reduction, but not both. This is a straw man. This committee and this assembly have always been in favor of and. I'm 100% supportive of drug treatment, and I support accountability for dealers. I'm 100% supportive of mental health treatment, and I support accountability for dealers. I'm 100% supportive of harm reduction, and I have taken harm reduction policy positions that many in my own party believe go too far. And I support accountability for dealers. We can do all of the above. Finally, the opponents will say that this bill reflects a return to the war on drugs and that whole mentality. And this is a strange accusation of me, and of course, nothing could be further from the truth. I've been in this assembly for almost 20 years, and most of my work has been focused on undoing the vast damage created by the war on drugs. This damage disproportionately impacted our African-American community, so our work has specifically focused on righting those injustices. I helped lead the charge to legalize cannabis, help create and structure our social equity licenses. With Senator Carter and Senator Muse, we've worked together to create a robust expungement regime. And even this session, I'm working with the governor's office to undo the damage of the Abhishek decision, which permanently harms former drug addicts with probation violations. The war on drugs accusation becomes even more bizarre when you consider who is supporting this bill. This legislation comes from my council member, Natalie Fanny Gonzalez, who is here to help translate today and represents perhaps the most racially diverse councilmanic district in the entire state. It's also supported by Montgomery County Executive Mark Elrich. Some of you know Mark, but for those of you who don't, Mark himself would be the first to tell you he is a lifelong 1960s radical. I didn't run this by him, but he may have cut off his ponytail and he doesn't wear Birkenstocks anymore, but his politics remain the same. Mark marched with Dr. King in 1963, and he too has spent much of his life fighting against the war on drugs mentality and passing policies to undo those wrongs. Mark is in favor of this bill and would be here to testify, but for our witness limitations here today. It's also supported by Anthony Brown, our Attorney General. And as everyone here knows, the Attorney General with Public Defender Natasha Dartigue founded the Maryland Equitable Justice Collaborative, which seeks to end mass incarceration and right the wrongs of the war on drugs. And it's supported by Victoria's, Scotty's, Ashley's, and Yardair's parents. And as you listen now to those parents, I hope you'll listen closely. Are they asking for vengeance? Are they asking for mass incarceration? Are they asking for a declaration of war on drugs? Or are they asking simply for what everyone else has in every other circumstance? A specific tool for their specific circumstances that would allow our legal system to hold their children's killers accountable under Maryland law. Thank you, Mr. Chairman.
Mr. Chairman and members of the Senate Judicial Proceedings Committee, Senator Justin Reed here for the record, echoing strongly Senator Waldstreicher's excellent comments, and only briefly because I think it's important that you hear from people most impacted by this. You've heard him talk about I like to say it's a nonpartisan issue. There is nowhere in our state, from the most densely populated and most racially racially diverse and economically diverse places to very, very rural areas, that has not been touched by the ravages of fentanyl. And the goal of this bill is very clear. We want to see justice for those who've been afflicted by people who push poison on purpose in our communities. It's a very narrowly tailored bill aimed at making sure that the people who are taking advantage of and literally killing our constituents see real justice, real jail time, but with plenty of protections to ensure that we are not targeting people who are dealing with addiction. I was, sometimes it may not be, a lot of folks that are here in the body weren't here when I first joined the Senate, but I worked very closely with a number of different state senators in both parties on justice reinvestment. And we worked very closely, I know, Mr. Chairman, of course, with you and others. And we didn't always agree on everything, but we did agree that one of the things we really agreed on was we wanted to be sure that people who had nonviolent drug offenses and an addiction were given treatment and help, and that's what we want. But we do have to have the stick of accountability that comes with those who are selling this poison in our communities. And so I think you have a wonderful coalition of people who are very politically diverse, racially diverse, economically diverse, who are asking for, and law enforcement, they're asking for tools to be able to be sure we can get some of these very dangerous people, and I think, frankly, folks who are behave very evilly out of our community, and protect our folks. So, Mr. Chair, excuse me, I thank you for letting me say a couple words today. I'm happy to be a co-sponsor on the bill with Senator Waldstreicher. And, I know we're happy to answer any questions when we're all done. Thank you. Scott.
Good afternoon, everyone. I want to thank each and every one of you for your efforts in this matter, especially those directly connected to my family. My name is Scott D. Broadfoot Sr. This is my son, Scotty. Scotty Broadfoot Jr. died from fentanyl poisoning April 12, 2019, at the age of 21. Today and every day, I stand with and support several groups, parents, siblings, spouses, and friends that may have lost a loved one poisoned to death by fentanyl. I have lived in Maryland my whole life. I'm self-funded, and I do not do this for vengeance. From the day we were born, we are taught right from wrong. We learn the consequences from our actions. Drug dealers need to be held accountable. Senate Bill 604 targets drug dealers. It does not target people with addiction. This law will not affect the Good Samaritan law. To give you a scenario, if you and I were sharing drugs and I give you a capsule and you overdose and die, but I survive, I will not be charged with murder under Senate Bill 604. Please closely read in detail this bill in its entirety. In Maryland, we have reached historic death numbers from potent levels of fentanyl. The number is so high, there is not a factual solution on record. In my son's case, there was a witness to the sale and the use of the purchased drug. The current laws are not effective for charges and prosecution. With Senate Bill 604, Victoria, Scotty, Ashley, and Yadar's law, it would give law enforcement the tool they need to charge and prosecute the dealers. I beg you to vote and pass Senate Bill 604 so the dealers poisoning and killing our loved ones are held responsible.
Most importantly, this is not a red or blue issue. This is a red, white, and blue issue. We must stand together. I will continue to advocate and bring awareness to this battle for every lost life and to educate every person living. I will never stop. Thank you.
Edith, ¿me escuchas? Okay, te voy a traducir. I'm going to translate. My name is Natalie Fanny Gonzalez. I'm a council member from Montgomery County. I'm going to start translating from Ms. Edith Montalban. Si puedes empezar, you're muted. Quita el mute de tu celular, por favor. Ahorita, habla, a ver. ¿Habla otra vez?
¿Escucha?
Sí, ahorita sí. Dale.
Mi nombre es Edith Montalban.
My name is Edith Montalban.
Gracias por darme la oportunidad de testificar a favor de esta ley SB 0604.
Thank you so much for letting me speak today in support of Senate Bill 604.
Ley penal de distribución de heroína, fentanilo, que causa lesiones graves y muerte.
The law that basically kills people using fentanyl.
La ley Victoria, Scotty, Ashley y Jader.
Continúa.
Soy la madre de Ashley Edward, una estudiante de 15 años de la escuela John F. Kennedy.
I'm the mother of Ashley Edwards. She was a student at John F. Kennedy High School.
Que lamentablemente falleció el 14 de enero del 2023.
Ashley passed away on January 2014, 2023, due to fentanyl overdose.
Esta droga está causando estragos en nuestra comunidad y es importante que tomemos medidas.
This drug is killing our communities, and it's important to take measures.
Para cambiar esta crisis que está cobrando la vida de tantos jóvenes y que ha dejado tanta dolor a muchas madres.
To make sure that this pill that is causing so much hurt in our community and is causing so many children to die.
Es tan triste perder un hijo.
It is so sad to lose a child.
Que nos cambia la vida para siempre.
It changes on our entire life.
Y que es lamentable que mueran de esta manera.
And it's so sad that they die in this way.
Hoy quiero pedirles, por favor, que pongan atención y que escuchen la petición.
I'm going to ask you to please pay attention and see and read this piece of legislation.
De estos padres que estamos rogando por una ley y justicia para nuestros hijos.
We are parents who are begging you to pass a law that gives justice to our children.
Que nos dejaron un dolor que nunca lo podremos calmar, pero que al menos estamos luchando y no vamos a parar hasta que podamos tener un mejor.
We are parents, we are organized, and we're going to continue advocating to pass laws that are just and protect every child. Okay, thank you so much. Okay, gracias, Edith. Can I say something? Very quickly, I just want to point out that I held a town hall meeting in my community with about nearly 200 people, very diverse. Parents came in, including parents whose children have died with an overdose. This is far overdue. We need to take action this year. In Montgomery County, we're proud that we have different centers for treatment centers for kids. Just in my district, I have about 50 kids right now going through treatment centers for kids that are using fentanyl. So that it's already happening. This is about going after those folks who are intentionally coming to our communities and going after the most vulnerable people in our society by giving them fentanyl. So please understand that we're not here saying that we don't want treatment centers. We're doing that already. This is an addition to the work that we already do in Montgomery County. Thank you so much. And I want to thank Senator Jeff Goldstryker for your strong support. Thank you.
Excellent. Thank you very much, Councilmember. Questions from the committee? Just for Edith, and, oh, well, go ahead. Senator Sidnor, go ahead.
So on page 2, first line, and the definition of what the word distribute means, well, let me read the definition. In this section, distribute does not include the sharing of heroin or fentanyl or chemical analog of heroin or fentanyl without remuneration or the exchange of goods or services. I am curious, the term goods or services, what the breadth of that term is. I can speak to the sponsor. What's your intention?
So we use so this phrase is taken from other laws that we have on our books. So this phrase, this term of art, is not uncommon in Maryland law and is not designed to include some of the examples that the opposition has submitted. And I would indicate that very few prosecutors, if any, would believe that giving someone a car ride would be considered a remuneration of some sort. Or a couple that slept together could be interpreted as, and that shared drugs, that somehow the sex could be interpreted as an exchange for those drugs. There's no, where this exists elsewhere in statute, there's no evidence that it is being used in an overbroad way to capture behaviors we don't want to capture. And without that evidence, it's hard to make the case that this language is somehow abusive because we already have it and we don't see any of those abuses.
Okay. And because it was I was thinking of some sort of a quid pro quo sexual exchange. You give me drugs, I give, but you said that's not the intention. This is strictly give me some money. Here's the drugs.
Yes, that is our intent.
Thank you.
Thank you, Mr. Chairman. Thank you to the bill sponsor and to the panelists for testifying and sharing your personal experience. My question is one of kind of tone. We are considering bills where we would give second chances to people who have intentionally taken someone else's life. And the tone of this legislation, it just seems counter to a lot of the great work that we're doing in terms of justice reform to give second chances. We understand Maryland's racial disparities in incarceration, and we've kind of identified two areas. One, we arrest and criminalize people very young in Maryland. And then the second part of that is once we have you in incarceration, we keep you for a very long time, and there's very little chances to turn your life around. So how does this work together with or against? How do you jive this bill and some of that other work that we've done on justice reform?
Yeah, that's a really good question, and thank you for asking it. It's an important one. I think you know that I've been supportive of those reforms, and I don't view this as counter to those reforms at all. In order for someone to have a second chance, they first must be held accountable for their actions. And under current law, because prosecutors are having challenges with our existing statutes and how they match up with the behavior here that we're trying to hold accountable, people aren't being held accountable. So Victoria's name, as I indicated, is on this bill. Her parents are not here. They're Pennsylvania residents. Couldn't come down in the snow. But her murderer is walking free, has not spent one day in jail, 18 months home detention. And I don't think that appropriately lays the groundwork for reform. So on the technical question you're asking, this bill does not undo any of those laws. In other words, if we pass this, someone who does their time will be eligible for all of those rights. So if we were to pass the second look law, for example, this would be allowed under that. Someone who is charged under this, convicted under this, could get a second look. If we were to pass the YES Act, for example, that requires children to start in juvenile court, a juvenile charged under this would start in juvenile court. And so all the reforms that we have done or are considering would still apply to this bill but they would only apply, as with any statute, after the person completes their term or is otherwise eligible for those reforms.
Absolutely. As it relates to the bill, have you had an opportunity to, we know our criminal justice system has a lot of racial disparities in it. Do you have any data that shows the kind of charges that are parallel, that are similar to this one, but don't go far enough in your estimation? Do we know who's being charged with those offenses and kind of if there's any sort of precursor that we could look at to try to figure out who would be most likely to be charged under this bill? Do we know from past data where that would likely go?
So I think we could get you data that would kind of hint at this. So the Sentencing Commission, we could look at the data for reckless endangerment, for example. But some of those people who are charged under reckless endangerment, which is what prosecutors try to use now, and is a 5-year misdemeanor and is struggling to match up with the conduct here, that can also be charged for reckless endangerment that has nothing to do with drugs, for other behavior that is reckless endangerment. And so, you know, if you were to fire a weapon in a crowded place, I imagine reckless endangerment be a charge. That has nothing to do with here, but that would be included in your statistic. Sure. So we can kind of like squint at what you're looking for, but it would be impossible to disaggregate which reckless endangerments come from homicide by fentanyl versus other forms of reckless endangerment.
I think what I'm interested in is the crimes of possession with intent to distribute, distribution of narcotics, kind of those crimes that kind of get a profile on who are the dealers that are being held accountable for this behavior. So I think there'd be overlap with whoever would be charged under this would be similar to the dealers that are being held accountable currently under our law. I want to also understand the role of intent. I don't know that every dealer that's selling fentanyl intends to kill the person that they're selling it to. I would presume they want that person to continue to patronize them and come back. So the presumption on my end would be that they don't want to see that life lost for their own bottom line. I guess the parallel with reckless endangerment you're making is that the intent to kill is not material in terms of you feeling they need to be held responsible in this way. Am I understanding that right?
Right. So with reckless endangerment, the standard is wanton disregard, and that is the appropriate analogy here. And my point about fentanyl being in everything is that when prosecutors attempt to use other charges, even if the intent is wanton disregard, they often are required to prove that the dealer knew that there was fentanyl in the product. And that's almost impossible to prove because dealers don't know with specificity the chemical composition of the drugs that they're dealing. And so my point in the extended testimony about what fentanyl is was designed to show you what all dealers know, even though prosecutors can't prove it with specificity, which is almost every drug sold today has fentanyl in it because of the market dynamics that create such an incentive to have fentanyl in every product. And so that's part of the problem we're trying to solve. We don't require in this bill for prosecutors to show that the dealer had specific knowledge of the fentanyl in the drug. As long as there was, in fact, fentanyl, we are imputing that knowledge. And the reason I think it's appropriate to do so is because they know and we know all drugs, unfortunately, now contain that fentanyl.
May I, just for the record's sake, offer a different perspective on that?
Sure, please.
If we are to believe some of the hyperbole surrounding juvenile participation in crimes, that perhaps very young people are selling fentanyl, or drugs that contain fentanyl in them. And perhaps those very young people who don't probably understand very much about life, maybe they don't have the knowledge of the dangerousness of what it is that they are selling or sharing with someone. But if I'm understanding your testimony correctly, that sort of element with an individualized view is not a part of the bill. It is presumed that everyone understands that regardless of their circumstance.
So I think the point you're making is an important one and a fair one. As you know, just kind of mixing this with other bills that we have here, in order to be charged as an adult, that statute has to be specifically listed in that portion of the code that says what allows you to be charged as adult. Because this is a new statute, it is not in that section of code. So as a juvenile, you could not be charged as an adult under this bill because it is not specifically listed in the section of code that allows you to do so.
Thank you for that clarification. The portion about serious bodily injury, I found that intriguing to include as well. In my mind, if you're prosecuting someone for that, the very best witness that a person was seriously injured would be that person themselves. Are we putting them in a position where the person who's the drug user could be compelled to offer testimony about their own drug use to prove this element against the person who's the drug dealer?
Well, a couple things. Certainly under the Fifth Amendment, someone is not compelled to testify in a way that creates legal danger for themselves. So no, they wouldn't be required to testify if they felt that that put themselves in legal danger. And then as to serious bodily injury, that is defined in code in other parts of the code. We could always add it specifically here, but that's a common phrase and that has a relatively high bar. We see that in first assault versus second assault, and so it means something really bad when that happens.
Okay. And then my last question, if I may be permitted a final. Thank you, Mr. Chairman. In law school, we all learned about the plaintiff with the eggshell thin skull.
Yeah.
That person who presents already in a condition where it doesn't take much for serious injury to occur or for that person to perish. Does your bill give any consideration for, because I guess the dividing line that changes this from just selling with a possession with intent to distribute or, distributing that is the death that occurs.
Right.
Does it give any consideration, any mitigation on if the person who did perish was already nearer to that ultimate fate?
So I think that would be a factor at trial. So causation is still a requirement here, and what caused the death would be an issue that would be part of the litigation for every criminal offense brought under this, as it would in any other circumstances, right? If you had what we would call an eggshell plaintiff, but here would be a victim, and they were hit lightly in the head, but fell down and died, in the same way that fact pattern can repeat in any criminal law issue, so too could it repeat here. I don't think it creates any fundamental difference between the bill that we've drafted and any other part of our code.
If that were fleshed out at trial, how would that change the sentencing or the finding of guilt if that were a factor that were discussed? Does it at all factor into the level of culpability for this?
So this was debated in a case, I think, called Maryland versus Thomas, another case where they were trying to figure out whether our manslaughter statute applies. And in that case, they said it did apply, but it's so highly fact-specific that it doesn't provide a lot of guidance going forward. But basically, the analysis there is it's a causation analysis. So someone could have a pre-existing condition, might have other drugs in their system, and so the question is a but-for question. Did this cause the person's death? And I imagine that the analysis in that case is not dissimilar from analyses we see in our courts every day.
Thank you.
Thank you.
Mr.
Good
Chair.
questions.
Thank you, Mr. Chair. I just want to go back to the exchange you had with Senator Sidnor and make sure that I heard it correctly or the record is clear. The discussion on distribution means with remuneration or the exchange of goods and services, and there was a discussion about sharing drugs and having consensual sex. But if someone were to require some sort of sexual act in exchange for the drugs, that would still be considered distribution, correct? If they say, you can't pay me, but.
Right. I think there's an argument that could be included. That's certainly not our intent. And I mean, I don't think there's any question, and we'll hear from the opposition, that we need to sit down and kind of figure out the language here. So I'm excited, honestly, to work with you guys and work with the opposition, at the conference room table to find wording that we can all agree on. Because just as we are well-intended here, so too is the opposition to this bill well-intended. And I think everyone comes at this with a desire to find a solution. And so I look forward to the opportunity to kind of figure these issues out with you, with other members of the committee, with the supporters, and with the opposition.
Thank you. Thank you, Mr. Chair.
All right, further questions from the committee? All right. Well, Edith and Scott, just thank you for your time. Thank you for coming down. And I always say this a lot, but it's hard to come down here, but it's much more difficult to come down here and to share your story. So I just want to say thank you for your advocacy. Thank you. Okay. With that, that'll conclude the hearing for the testimony for the proponents of the bill. And I'll switch to the opposition panel. And Mr. Franklin, and is Tony Torch here? Tony?
Mr. Chairman, pleasure to see you again, and thanks for having me here. Senator Wallstreicher, I want to thank you also for your attention to the serious state of drug overdoses in Maryland. As a 34-year police veteran who worked undercover narcotics and at one time oversaw 9 multi-jurisdictional drug task forces, I take this matter very serious. No one has been more committed to going after drug dealers than me. Fortunately, my past police career has taken me deep into the space of collaborating with people who use drugs, thus understanding the perspective of drug use, addiction, the environment of habits, challenges, relationships, stigma, and the compelling need for secrecy. I also understand the frustration relative to the current state of overdose deaths in the state of Maryland and your intent of SB 604. But I caution the use of more punitive laws that have the potential to push more users deeper into the shadows of drug use and isolation. Isolation is the opposite of connection, and connection is what's necessary for overcoming addiction. I know how this legislation will play out in the policing world. There's no doubt in my mind that police will target people who do not intend this law to be for. As it is written, those at the end of the food chain who commonly exchange products and services for drugs will get caught up in the drag nets. Prosecutors already have sufficient laws on the books for going after and prosecuting predator drug dealers higher up in the food chain. In 2017, I personally worked 2 such Maryland cases, one in St. Mary's County, one in Charles County, as a witness requested by the Public Defender's Office. The problem with those cases is that they successfully prosecuted the friends of the deceased for manslaughter, not the higher level drug dealers. And I see my time is up. So in conclusion, I've submitted written testimony in detail covering all of this, including the expense and some of the things that you have talked about. So please study that legislation and also look at Eric Sterling's, and he covers the another point that was brought up by the senators. Thanks again for having me and letting me testify.
I'm so nervous I could pass out. I'm sorry. Thank you. Good afternoon, Chair and members of the committee. Senator Wallstreicher, I'm so glad that you brought up there are other laws on the books, and that I believe one of the charges that do include fentanyl, that I think it carries 20 years. It is concerning to hear the word intent and the view. My son Danny died at the age of 24 of an overdose, and I once supported this type of bill. Anger at the time and this immense pain, it fills you, it fills your body. And I wanted to put my finger on the cause. I wanted to have someone pay for this and hold somebody accountable. But now I know that's not the way to reduce overdose deaths, because I think that's probably all of our goal right now. But through my work in the community, I've witnessed what's worked and saving lives. I'm the director of the Daniel Carl Torsch Foundation, and actually some of our outreach workers are with us today. We provide various health-centered harm reduction services, including prevention and recovery support, to approximately 400 people a month. And partly that's because of you. You previously voted on a budget that included significant funding for prevention and treatment that we were fortunate enough to receive a small grant. And we're seeing the results of your careful decisions. We're boots on the ground providing direct services daily to the people in active addiction and or recovery. I've documented an increase of almost 30% in the number of requests for treatment in the past 14 months. And that happens by earning the trust between us and the individuals we're serving, by using best practices. These penalties will affect those whose behaviors may indirectly lead to a death. My son Dan was probably a user and a dealer, maybe just on different days. We've spent an enormous amount of time on Good Samaritan laws and the messages. Senator Smith, Senator Sidnor, you know the hard work that went into that. You were the sponsors of one of those bills. These penalties will undermine all of that work in progress. If the bill passes, it won't take long for the community to hear of the penalties. They won't pay attention to the tweaks and hinted provisions of the bill. It will undo all the great work of finally getting folks to call for help in the event of an overdose. It's with 100% certainty deaths will rise again. These types of laws have a limited deterrent effect and have never been proven to reduce drug-related deaths. The use of the word sharing, never is there a free drug usually. It's always some kind of behavior. It's a ride, it's something that they're trading. It's never free, just to share. My message is not to let all criminals have a get out of jail free card. You now have to decide if throwing on another penalty on top of the laws we already have in place is the direction to go to reduce overdose deaths. The keys here remain treatment and prevention, not prison. There should never be a disincentive to get or receive help. Last year, Maryland saw a 38% decrease in overdoses. So we don't need to go backwards.
Thank you very much.
Behind me in the green shirts are other parents and professionals, people that have overdosed and own recovery programs and treatment providers. I'm asking for a non-favorable report.
Thank you very much. So you have a little bit of grace, because I know you did an awesome job. Thank you for your time. This is great. Senator Henson.
Thank you, Mr. Chairman. My question is for the gentleman. When we thank you for your testimony and your expertise. When we have very long criminal or lengthy criminal penalties, like a 20-year sentence, in my mind, there's kind of two goals. One is you perhaps want to get that person off of the street and want to neutralize them as a threat to the public. And perhaps you want to do that for a very long time because you feel like that has value to public safety. And then the second is that you want to deter people. You want other people to hear that there's this very long sentence, and so people will say, hey, I'm out of that business because I don't want to be in jail for 20 years. The latter, in my opinion, is not a strong incentive. So often the deterrent factor that we think we're going to get doesn't materialize. As a person who has been a practitioner in this area, worked in law enforcement, have you seen significant deterrent values if we were to increase the sentence on this? Do you think that translates to the streets where people who are selling fentanyl say, I think I won't because I want to avoid this penalty?
Well, Senator, no, it won't. Not the predatory dealers that we're talking about here that we're trying to apply this law to. On average, it's 9 years for fentanyl. They can go up to 30 years already. They already know this. So, you know, the penalty's already there for that, and they can be imposed if the case warrants it and the judge decides it. So it's already there. What we're talking about here is for that user population. And again, my post-policing career educated me on this in my interaction with people in the user population, that environment, there's a lot of quid pro quo. Some of it's money, products and services. It happens all the time. And in the two cases that I've referenced, one in St. Mary's County, one in Charles County, that was the case. One person sells a little bit to make money to support their own habit. And they were prosecuted successfully under our current laws. My point is that the intent of this is to go after those dealers that are out there preying upon the user population. We can already deal with those folks. But in the dragnets that will occur, I understand the policing world. I've worked in it for 34 years, and most of that in drug enforcement and criminal investigation. And I know how it works, especially when the pressure is put upon you to go after certain people. And I'm just afraid, from what I've seen in my career, that the people who need the services, and I would like to say that over 10 years, it's projected that we will spend $26 million if 8 people per year are prosecuted and sentenced under this law. $26.9 million. You know how far that could go with what you've done and will continue to do, obviously, in the treatment world, with making treatment more accessible to people who need it. That's a lot of money, and that's 2024 dollars. Also, just one more thing, as it relates to disparity issues, I really encourage you to take a good look at Eric Sterling's report that he sent to you guys, his written testimony. He breaks that out using data from sentencing data, prior sentencing data that's already been collected, and what that would look like from a disparity perspective. And it's alarming. We all know, I think we all know that when it comes to like drug crimes, that blacks and Latinos, Hispanics are arrested at higher rates, they're prosecuted at higher rates, they're sentenced at higher rates, and they do more time. And I don't see any reason why it would be any different.
Thank you for your testimony. Thank you, Mr. Chair.
Excellent, thank you. Further questions from the committee? All right, with that, that'll end the hearing for Senate Bill 604. Thank you all very much. We'll now move on to Senate Bill 624, Senator Lamb.
All right, I think there are a few members of the sponsor panel. We have Jesse Bennett, Jennifer Johnson, and Christine Simmons. Oh, they're all on Zoom. Are you seeing them on this virtually? Okay. All right, so go ahead and begin. All right. Good afternoon,
Jesse Bennett,
Chair.
Jennifer Johnson, and Christine Simmons.
While the senator is testifying, Mr. Bennett, if you could, if you're streaming the hearings, if you could just close down the tab that you're streaming the hearings from, and we won't get that feedback. Excellent, Senator. At your leisure. Thank you.
All right.
Sorry about that.
Sounds good. No problem. All right. Thank you, Chair Smith, members of the Judicial Proceedings Committee. Thank you for allowing me to testify and introduce Senate Bill 624. For the record, Clarence Lamb, Senator District 12. This bill was brought to me by advocates who helped to try to address a frequent issue that we're seeing in some of our farms, some of our cemeteries, where a cemetery is sold and redeveloped without any real notice to the families of individuals buried in the cemetery. There are multiple concerning examples over the years of people having their remains and the remains of their relatives moved by a developer without their knowledge, or as well as several examples of people being unable to locate their relatives' remains afterwards. Under current law, an individual is able to move human remains as long as they provide the local state's attorney with evidence that they've published a notice in a local newspaper. If a family member misses the single published notice, they may have no knowledge of the plan to disinter their loved one until after the work begins. Under this bill, disinterment requests will be overseen by the Office of Cemetery Oversight and will require increased public notification, including public posting at the cemetery itself. Additionally, interested parties can ask the Office of Cemetery Oversight to host an information session, and family members can request that the disinterment be delayed. This will ensure that family members will have the time to learn more about the proposed disinterment and to move their relatives' remains themselves if they prefer. That's really the basis of the bill. The rest of it is, as you can see in the bill draft, the bill text itself, and happy to turn over to other members of the panel and take questions as a panel at the end.
Excellent. Thank you very much, Senator. All right, Mr. Bennett, you're up.
Can you hear me now?
We can, yes. Welcome.
Great. Good afternoon, Chairman and members of the Judicial Proceedings Committee. My name is Jesse Bennett, and I'm a volunteer research coordinator for the historic 153-year-old Mount Auburn Cemetery located in Westport, Mount Winans area of Baltimore City, Maryland, where over 64,000 burials have been identified. I'm a member of the Maryland Cemetery Legislative Advocates. My great-grandfather is buried at Mount Auburn. Although there have been very few disinterments on record for our cemetery over the past 25 years, I guess that means we're doing a good job, I'm here to support SB 624 and its effort to clarify the process of improving the rules for disinterment. The monitoring by the Office of Cemetery Oversight would reduce the number of complaints received and provide the state's attorney with the ability to refer people to the Office of OCO. Then disinterment, reinterment, and/or relocation records shall be retained by OCO and accessible. Thank you for having me today.
All right, sorry about that. Sorry about the pregnant pause there. Jennifer, you're up. Ms. Johnson, welcome.
Yes, thank you. Good afternoon, Senator Smith and Senator Wallstreicher and all committee members. Thank you for allowing me to present to you today. My name is Jennifer Johnson, and I am the founder of Friends of St. Peter's Cemetery. I founded the organization in 2023, and I am also a member of the Maryland Cemetery Legislation Advocates. I ask that you support Senate Bill 624 and its efforts to make a more organized and streamlined process, giving additional oversight from the Office of Cemetery Oversight, such that people's loved ones that do have to be disinterred for any reason are properly handled. I come from a line of 4 generations of funeral directors. My family's funeral home was the Hicks Funeral Home out of Annapolis. And so it has been instilled in me from birth the importance of taking care of the dead. And I ask that you give a favorable support for this legislation. Thank you.
Excellent. Thank you very much. We'll have one more guest, Christine Simmons. Ms. Simmons, welcome.
Well, good afternoon, Chairman, Vice Chairman, and members of the Judiciary Committee. Thank you for allowing me to testify. I'm Christine Simmons. I'm representing the Anne Arundel Genealogical Society and the Maryland Cemetery Legislative Advocates. I've been involved with researching cemeteries in various capacities for 40 years. During that time, I've collected information on only a dozen or so individuals or cemeteries that have been moved, where both the initial site and the disposition are known. Funeral homes, county health departments, state's attorney's office all sign off on these permits, but typically don't keep copies of the records once they've been moved. Sometimes burials are moved by family members or loved ones who live in another area. The final disposition may be in a different county. It might even be in a different state. Sometimes they're moved due to road construction or development. There is already a Maryland law dealing with reinterments, but we need more oversight. Often moves from small cemeteries to commercial cemeteries or memorial gardens don't take the tombstones along or allow them in the cemetery. The office may not even show that there's a reburial or the original location of that grave. People researching their family's histories are often confused by not finding the loved one where they expected. Since there's no central repository for these records, we may find a dead end unless they can locate cemetery records showing that location. The Maryland Division of Vital Records has one small box of records. The Maryland State Archives has 2 small boxes. I've looked at both of these. The Maryland State Thank you very much for your time. I appreciate your support of this bill.
Excellent. Thank you very much. Questions from the committee? All right, Senator Lamb, thank you very much.
Thank you.
All right, thank you all. With that, that'll conclude the hearing for Senate Bill 624. We'll now move on to Senator Muse with Senate Bill 649 and Senate Bill 650.
Good afternoon, Chairman Smith, Vice Chairman Wallstreicher, and members of the Senate Judicial Proceedings Committee. I am not Senator Muse. I am Brandy Calhoun here on his behalf. I serve as his legislative director. I'm here today in support of Senate Bill 649, Criminal Procedure, Expungement, No Finding, and Case Terminated Without Finding. On the sponsor panel, we have Christopher Dews, Martin Mitchell, and Megan McDermott. Senate Bill 649 is a technical fix to the expungement statute that will allow charges designated as a no finding to be eligible for expungement. As you know, expungement is available for acquittals, dismissals, and a limited selection of misdemeanors and felonies. In Prince George's County, many residents have a unique legal status called no finding, which is not explicitly defined in the statute and prevents them from being eligible for expungement. The issue with no finding is that this designation leaves individuals in a legal limbo. Although these individuals are not convicted, their records are marked with a no finding status. This technical distinction still appears in criminal background checks and must be disclosed to employers. Despite the absence of a conviction, they are effectively denied the opportunity to clear their record, even though they would otherwise be eligible for expungement. This was, I guess, found out this year by Delegate Taylor when she did an event and she found that there was no finding in Prince George's County. So that's the reason for this bill. In closing, expungement has the power to eliminate court and arrest records, opening doors for employment and housing opportunities. However, for individuals with no finding designation, their record remains tainted and their past remains a barrier to success. These residents whose charges would otherwise be eligible for expungement are unjustly held back by this legal barricade. Senate Bill 649 will correct this oversight and help give them a fresh start they deserve. Therefore, I respectfully urge a favorable report for Senate Bill 649, and Senators panel will speak to the technical aspects of the no finding designation, its impact, and the proper implementation of this bill.
Good, almost evening. Members of the committee, Christopher Dews with Cornerstone Government Affairs, representing Out for Justice for the purposes of this conversation. I am also the chair of the Maryland Expungement Coalition, and this is an interesting piece of legislation. It involves a designation that we had never heard of before. You'll see if you read the policy and fiscal note, or even some of the unfavorable testimony that I feel like you may have already glanced through, there's a lot of confusion as to what this designation is, what does it mean to be unequivocal, and just a lot of confusion around it. And there's not a lot of data on it either. In the policy and fiscal note, I believe it is just a definition of what expungements are because there is no information about it. So this is not something that is normal, not something that is usual. We have found that this is only something that we've seen in Prince George's County. I'm going to pass it over to Ms. McDermott from Maryland Legal Aid, who is kind of the expert on all things on this. And I just wanted to give a little more context to why or where this bill came from. As Brandy had alluded to, an expungement clinic was held in Prince George's County, and a variety of members were saying that this was something that they had, was they were not able to get it expunged, even though the underlying charge would be eligible for expungement, even if they were found guilty. And so we're thankful to Delegate Taylor and Senator Muse for sponsoring this piece of legislation to kind of address and fix this very, very slight and somewhat confusing technical issue. I'm not going to hold any more of the time, but we are here to answer any questions about the origins of this, what this means, and kind of explain the technical sides of it as well. Thank you for your time.
Good afternoon to the committee. My name is Megan McDermott. I'm an advocacy director at Maryland Legal Aid, where I supervise the bulk of our expungement practice. Senate Bill 649 would allow no finding and case terminated without finding dispositions to be expunged. These dispositions function as convictions, but because they are not typically used in Maryland, they were never incorporated into the expungement statute. So why do we care? Why are we talking about these dispositions that are not part of Maryland law? Because thousands of Prince George's County residents are faced with a bizarre roadblock to expungement. For decades, these individuals were asked to plead nolo contendere, or no contest, in criminal proceedings. Usually in Maryland, such a plea would result in a guilty conviction. But in these cases, a no finding or a case terminated without finding disposition was entered instead. This practice went on for about 40 years, likely in an attempt to give folks some relief from being associated with a guilty disposition. However, since that time, as this committee well knows, Maryland has expanded its expungement statute a lot, and it includes convictions. The tangible impact of expungement greatly surpasses any positive gain from receiving an obscure disposition. And so, Prince George's County individuals who in effect received a guilty disposition and served sentences and are otherwise eligible for expungement have been left behind without access to it. It's clear that this is unfair. People should not be penalized because of a rogue legal practice, no matter how well-meaning it was. Senate Bill 649 would allow cases with these specialized dispositions to be expunged using the same standards as convictions. Please report favorably on Senate Bill 649 so all Marylanders have equal access to expungement and therefore to economic stability. Thank you.
Good evening, Chair, Vice Chair, and members of JPR. For the record, my name is Martin Mitchell. I'm here today on behalf of Life After Release. Life After Release is a reentry-based organization in Prince George's County, Maryland, that helps our brothers and sisters returning home and some while still in a carceral state. As a dedicated advocate for criminal justice reform and a former city council member, as someone who hosts quarterly free expungement clinics in the community, I understand the importance of expungements and how life-changing they can be. Over the last 3 years, I've hosted about a dozen record-clearing clinics and Know Your Rights clinics. I've personally been able to see people go from retail jobs to the medical industry now because of that expungement. In my work with Life After Release, I have seen the devastating impact that an arrest record without a conviction can have on individuals seeking to rebuild their lives. Many residents, especially in Prince George's County, are caught in a legal limbo due to the no findings designation. A status that is not explicitly defined in statute, but still appears in background checks, forcing individuals to disclose it to employers and landlords. SB 649 is necessary and an overdue fix to our expungement laws. It will allow charges labeled as no finding to be treated in alignment with dismissals, acquittals, and ensuring those who were never convicted are not unfairly punished. Expungement is about fairness. It is about ensuring that our justice system does not continue to penalize people who have already been cleared of wrongdoing. For those affected, the bill is not just a policy, it is a lifeline. This is a common sense bill that would allow second chances for more Marylanders. I urge this deliberative committee to issue a favorable report for SB 649 and to help provide a second chance that so many in our community deserve. Thank you for your consideration and taking this time.
Excellent. Thank you very much. We'll go to Ms. Rothstein first, and then we'll open it up for questions.
Thank you.
Thanks.
Thank you, and thanks for promoting me to the sponsors table. Good afternoon. My name is Melissa Rothstein. I am the Chief of External Affairs at the Maryland Office of the Public Defender, and I urge you to issue a favorable report on Senate Bill 649. As you already heard, this bill is a technical fix to provide the same expungement availability to a no-finding disposition as is available to other findings of guilt for the same charge. It was uniquely used in Prince George's County from the early 1990s through 2019. At OPD, we estimate that there were more than 600 of these no-finding dispositions a year for those 25-plus years, totaling more than 15,000 cases that should be available for expungement but are currently denied. A no-finding disposition would arise when someone entered what is known as an Alford plea. The person pleads guilty by not contesting the charges, but also without admitting to any of the underlying facts. These dispositions can result when someone wants their case resolved with less sentencing risk and quicker resolution, and the court agrees that something less than the prosecution's plea offer or trial demand is appropriate. It was specifically used when there was a circumstance that mitigated against a traditional guilty plea and was intended to further that mitigating circumstance and reduce the consequences of the plea. This bill does not expand the types of cases available for expungement, nor does it alter the time frame for when a conviction can be expunged. Rather, it allows for specific Prince George's County residents to have the same expungement of eligibility as other Marylanders, regardless of how the judge accepted their plea. As you are aware, a criminal record can create insurmountable barriers to employment, education, housing, occupational licensing, and public assistance. The General Assembly, particularly on bills that began with this committee, has made great strides in increasing the availability of expungement to remove those barriers for most misdemeanor convictions. This bill will apply those reforms to people who received a no-finding disposition so that they too have restored access to work, housing, and other basic opportunities after the designated waiting period. For these reasons, I urge the committee to issue a favorable report. Thank you.
Chair, I find this bill very interesting. 2 years ago, I worked long and hard to try to come up with a new form of probation before judgment. And it was really difficult to get all of the interested players together to agree on the language of that. And we needed to agree on the language so that the courts could use the new form of probation before judgment in an appropriate case. So here we now we find that in Prince George's County, the courts were entering a disposition which was not sanctioned by a statute, but just with doing it. So I spent all that time coming up with the incredibly convoluted definition of the new form of probation before judgment and put it into statute so it could be used by the courts, only to find in Prince George's County cases have been disposed of. I guess my concern about this is there's no definition of what a no-finding designation or a termination without finding is. And we might be inadvertently suggesting to courts across the state that such a disposition of cases is okay. And I don't think we should blithely create that impression unless we really mean to do it. And I don't think we do mean to do it. So I think, I don't know who's speaking for the sponsor of the bill. Would you have a problem if we amended this in order to put some kind of a definition of no finding or termination without finding, which defines it as a practice that occurred in Prince George's County up until 2019 and is no longer being practiced in Prince George's County, and this statute should not be construed as suggesting that such a practice should be engaged in any other circuit courts in the state.
They seem to be the elected representative. Yes, to me, that sounds reasonable.
Okay, thank you.
Thank you, and my questions will reflect that I do not practice criminal law. So I just need to understand this because I see the problem and I see the oddity, I guess, and I'm glad that Senator West brought up one of my concerns, which is let's make sure we confine it if the problem is really coming out of Prince George's County. So it sounds like what you're saying is that a practice sort of evolved with the judiciary in the county to try to deal with not so much people that were absolutely innocent or exonerated, but there were some complexities to their cases. The judges, prosecutors, maybe the public defenders were trying to work through a lesser determination. Somebody mentioned oftentimes these were used in lieu of an Alford plea, and I think an Alford plea is also a no contest kind of plea. What first what does an Alford plea mean, or no contest if they're the same? What is the defendant saying? What's the court saying about the circumstances? What does that mean? And then I'll ask you, once I know what that means, I'll ask you another question. Anybody?
Melissa, you can answer if you'd like.
Did she hear me?
Oh, she might be frozen.
She might be frozen.
There you go. Okay, Melissa, there you go.
Oh, am I frozen?
No, now you're not.
You're unfrozen now.
Okay. So, I mean, this basically is an Alford plea. I mean, both of those are when there's an exception, there's a, that a guilty plea is accepted without having to admit to any of the underlying facts of it. And so this is basically similar to that. And then it's a matter of how it was recorded in those cases in terms of the disposition of it was, instead of putting it as guilty, it was put as a no finding.
So I just want to make sure. So you have pretty confident that in all these cases, it was an Alford plea type situation or a no contest kind of situation, which is some version of guilt, but I don't want to get into the minutia of it, but it's a finding of guilt, but not quite the same as it's the defendant himself's not going to put up a defense, and then we're going to work through a different kind of remedy or punishment or whatever it is. So you're pretty confident that's the bulk or all of these cases. So if we were to sub out and say, hey, guess what? It's kind of that weird guilty plea. What you're suggesting is, hey, since other guilty pleas are, findings of guilt and you get a conviction, they can at some point down the line ask for expungement under existing law that we've already passed. We've inadvertently, because of the oddity of this particular circumstances, excluded a group that ought to just be back in that pool of eligible people asking under certain circumstances to get expunged. Is that what you're saying?
Yeah, I mean, the bill is putting this within the section of expungements that deals with guilty pleas. It's not giving to this person anything more than those. I can tell you, in speaking with folks who've been in our Prince George's County office for some time and talking to them about when this happened, it would often be there so that the person could come back and then get a more favorable disposition later, and which we're not suggesting should be part of what happens here. We're sort of saying here, just treat, that was no longer able to happen because sometimes the judge was no longer available. So. So this is basically a way to put this on even standing with other guilty pleas.
And then do you know why? Well, probably none of us will ever find out why it started, but but everyone's very confident it ended in 2019. So anybody want to just enlighten me on why it ended?
I mean, I can tell you it was a specific judge in a specific docket, and it was done, as you may be familiar, if you practice in other ways, there are variances that happen by different judges.
Big one.
And so, and this was something that was being done in sort of those circumstances where there was something, there was a reason to consider something that would be more mitigating. And then because you no longer have the availability of changing what that disposition is, and it isn't a disposition that's available by statute, it then put people in a worse.
All right, thank you very much. That's very helpful.
No, the judge is deceased. And I did just want to comment on the amendment. The judge did practice in other jurisdictions sometimes once he retired. So if we were going to do an amendment, it might have to be time only and not Prince George's County specific. I have never seen this outside of Prince George's County. I don't think anybody else has either, but because he did sit in other jurisdictions, we might want to, any amendment might not be able to be specific to Prince George's if we want to address this. Oh, sorry.
Further questions from the committee? Okay, thank you all very much. Thanks. All right, we'll now move on. That'll conclude the hearing for Senate Bill 649. We'll now move on to Senate Bill 650.
Good afternoon again, Mr. Chairman, Vice Chair, and members of the Senate Judicial Proceedings Committee. For the record, again, I am Brandy Calhoun, Legislative Director for Senator Muse, who represents the 26th Legislative District in Prince George's County, here in support of Senate Bill 650, Criminal Procedure Domestic Violence Registry. With me on Senator Muse's sponsor panel is Robin Becker and Nina Newman. Both are representing the Prince George's County State's Attorney's Special Victims and Family Violence Unit. Unfortunately, State's Attorney Aisha Braveboy could not join us today, but she has been very instrumental in advocating for this legislation through extensive community engagement. In fact, State's Attorney Aisha Braveboy held a series of community meetings across the county, in Prince George's County, of course, where she actively gathered input from domestic violence victims and advocates. It was through this direct feedback from the community that the idea for a domestic violence offender registry emerged. Victims voiced a clear need for a registry to protect survivors and prevent repeat offenses. And State's Attorney Braveboy has worked tirelessly to turn this input into the proposed legislation you have in front of you today. Senate Bill 650 establishes a domestic violence offender registry in Maryland to track individuals convicted of domestic violence-related crimes. Some of the key provisions of this bill would include offenders convicted of 3 or more domestic violence-related crimes must register with the local sheriff's office upon release, probation, or non-incarceration sentence. The registry would include the offender's name, address, crime details, and a photo. Public access will be available online, by phone, mail, and in person. Offenders will stay on the registry for 15 years with possible extensions for new crimes. And offenders can petition for removal after proving they no longer pose a threat. This bill is critical as domestic violence continues to rise both statewide and in Prince George's County. In fact, in 2021, Maryland reported over 58,000 domestic violence incidents, and in 2024, Prince George's County saw a 13% increase in cases. The registry will help address repeat offenders and enhance community safety. Senator Muse also has an amendment to make the registry prospective, addressing the concerns of the Maryland judiciary. On behalf of Senator Muse, I respectfully urge a favorable committee report, and we'll turn it over to his sponsor panel.
Thank you. Good afternoon, Chairman Smith, Vice Chairman Waldstreicher, and distinguished members of the Senate Judicial Proceedings Committee. It is an honor to be here testifying before all of you on this issue of great importance. For the record, I am Assistant State's Attorney Robin Elizabeth Becker of the Prince George's County State's Attorney's Office, Special Victims Unit, and I am here today to express my strong support for Senate Bill 650, the Domestic Violence Offender Registry. Under the current law, there is no system in place for potential victims to know about an intimate partner's history of abuse before they enter into and potentially become trapped within dangerous relationships. What is particularly insidious about these types of offenses and the patterns that we see in our office is that these perpetrators prey on love. What we know about the cycle of abuse is that the abusers initially present as great partners. This is prior to manipulating the victim and getting the victim emotionally attached. These offenders specifically prey on that emotional attachment. They prey on love and then use that love as a tool to coerce, control, and abuse. And if only these victims had been informed from the beginning, they would have been able to make informed decisions about who to allow in their lives, as well as, in many cases, their children's lives. These children are often witness to their own parent being abused, and in some cases are abused themselves. Further, when children are exposed to domestic violence, they are systematically more likely to become perpetrators and/or victims of domestic violence themselves. For these reasons, I respectfully urge a favorable report on Senate Bill 650, and thank you for your consideration of this important legislation.
Well, it's officially evening, so good evening, members of the Judicial Proceeding Committee. Mr. Chairman, Mr. Vice Chairman, thank you for the time and opportunity to speak to you. My name is Nina Newman. I'm an assistant state's attorney in Prince George's County, Maryland, and I'm specifically a part of the Special Victims Unit, and I prosecute felony domestic violence crimes. And I'm here to express my support for the Senate Bill 650 Domestic Violence Offender Registry. Being a special victims prosecutor gives me the unique opportunity to meet with victims on a weekly, if not daily, basis, victims, survivors of domestic violence. And an overwhelming pattern that I am constantly being presented with when meeting with victims, prepping for trial, is that these victims find out through non-traditional means that their intimate partner, their current abuser, had previously abused other intimate partners that they had before. Our victims are finding this out through social media, through Reddit forums, Facebook pages, prior intimate partners reaching out to them, and word of mouth. That is the current system that we have in place for victims to know the history of their domestic abuser, of their prior intimate partners. Now, not only the experience that I have been noting, but there was a study, a group study think tank done by the Governor's Family Violence Council in the in the spring of 2024, where 69 survivors of domestic violence were met with, and they engaged in over 20 hours of conversation across the state of Maryland to identify ways. These victims in this survey unanimously came before them and advocated that there be a law change bringing about a domestic violence offender registry to better protect and prevent future domestic violence. Thank you.
Excellent. Thank you both very much. Questions from the committee? Senator James.
So first, I guess this is the first time this bill's been here. Maybe not, but I had not read it before. So my initial reaction was pretty positive, but, you know, I read through the testimony, so I'll give you all a chance to just respond. There were a couple of oppositions to it, but putting aside the judiciary's retroactivity, which I get, you get, so. But a couple of groups said, look, not that anybody's against the concept, but maybe unlike the child sex registry, which, you know, where obviously also has prohibitions about where the person lives, proximity to small children, schools, daycares, and things like that, and just the general vulnerability of children. I'm not suggesting that others aren't vulnerable, but the idea is that the argument they're making is, look, first of all, it's a teeny tiny population that ever gets through the both being prosecuted or charged, prosecuted, convicted. So not that that makes that the problem, but it's a tiny little subset. Two, they claim, I didn't see any data, it doesn't lead to a reduction in recidivism. So maybe that's not your goal. I don't know yet. It sounds like possibly your goal now that I'm hearing you is, hey, it's about getting better notification so that mainly women, but can make maybe more informed decisions. But given that they're sort of saying, hey, look, this just doesn't really reflect the depth and breadth of the problem, it doesn't result in reducing this terrible habitual repeat behavior, and maybe they think there's other ways you can. Can you want to just respond to that? And you can be free to say, look, the real thing is about notification, and it's just one more way to notify potential victims. But I would like to hear your response to some of the criticism and to the bill.
Yes, Senator. So that is correct. I mean, the bill itself does not do anything to reduce recidivism. The bill itself is about prevention and protection. It's about knowledge. It's about empowering potential would-be victims with the knowledge of who it is they're considering getting involved with. And when they are armed with that knowledge, they are empowered to make informed decisions for themselves about whether or not they want to allow this person into their life.
How would you envision, I don't know if the bill even spoke to how you would disseminate this information? I mean, obviously, I heard what would be in the registry, but a registry is a registry. It could be over here in a nice vault, and nobody would know. You know, I don't know if this is true everywhere else, but in Harford County, they actually print occasionally the sex offender registry people in at least your community, because I had somebody living on my farm that fell under it, and people all called me and worried about it. But so there were some ways of public notification. Does the bill address it, or what is your vision for how, you know, there's a million girlfriends out there, you know, a million people could become victims. How do you envision getting the word out so it will have this protective layer or this prevention layer that you hope to accomplish?
Right. So the vision is that it would mirror, right, as you had mentioned before, Senator, the sex offender registry, that there would be a designated website that you know, that anybody, you know, could go on and type in a name and look to see if this person has a history of these types of offenses, so that they can better.
But do you think people will? I don't know what. I wouldn't go up and look at a registry when I'm picking a boyfriend, but that. You know what I mean? But maybe I'm not with it today. Yes. So I don't know. I'm just, do you think, is that what the victims are saying? We would have gone to, whenever we're about to date somebody, we will definitely go and check them out on a registry, or what do you?
Thank you for bringing that up, because in that group study I was mentioning for the Governor's Family Violence Council, of those 69 survivors that were consulted and recommended a domestic violence registry, they put in direct quotes from these anonymous survivors. And one such survivor stated, one of the things that she's advocating for in Annapolis is for a database created of people who have gross domestic violence criminal backgrounds. You know that in some way, you know the community that you live in, or if you potentially date somebody, you can know that this person definitely has done this in the past and be warned. So I do believe that this is something that victims who have already gone through the abuse are saying they wish they had known in advance that they could have this opportunity to look up a domestic partner's prior history. I also believe that as far as envisioning that victims would be able, or potential victims or potential intimate partners who may have concerns or may have been presented with hearsay from somebody else and they want to look into this further, they'd have an opportunity, whether it's a website or something. My vision would be that they'd be able to type in this person's name, type in the address, and then get a comprehensive list of the specific crimes that they have committed previously. As for recidivism, I do believe that this bill will have some recidivism.
I know, it's quite a word.
I do believe it would have that impact because it does provide added accountability. And after the 15 years, if there is another violation in which they are convicted subsequently after the 3 convictions that are required to become on this registry in the first place, they would have to stay on for 20 more years. So I do believe that there is a chance for individuals who are on the registry to work not to have further convictions. I don't think that's the main purpose, but it may have some effect.
And then just one last, so if we create the registry, and I read that it would be 3, to get on it, you'd have to have, which is generous, 3 incidences of domestic violence, or I think there was another.
Domestically related crimes.
Crimes, right. Then once you're on the registry, is that all I mean, it's a lot, but is that all you would see? Or if someone had a more extensive history with or without it coming under these 2 criteria, would all of that be available? Or do you envision it being the 3 crimes that got them on the registry?
I think that's a good question. In reading the bill and the language as it comes, it states that it would list their criminal history, and it doesn't specify.
Right. I don't know.
I don't know the answer to that.
I don't either.
However, if this is a domestic violence offender registry and it puts their domestic related crime convictions on there, at least that is enough warning for a potential victim who can then go through and navigate the very complex system of case search, record search, and see if there are more convictions there. But I think that it's up to interpretation and things.
We might have to clean up that language
later.
if we don't want there to be confusion.
Exactly.
All right. Thank you, Mr. Chairman.
Thank you, Mr. Chair. I'm looking at the fiscal note for this bill. It says general fund expenditures for the Department of Public Safety and Correctional Services increased by at least $1,389,146 in fiscal 2026. And then it goes on and says DPSCS also anticipates significant personnel costs to hire 15 staff, with general fund expenditures increasing by $1.1 million in fiscal 2026. So we're looking at $2.5 million in round numbers as a cost for this. Has anybody approached the Budget and Tax Committee to see whether or not they're willing to allocate that amount of money to this coming year's budget to pay for this?
I don't have information as to that, and I would
say no, we haven't, because we just got the fiscal note yesterday, so we
Okay.
haven't, yeah.
All right. I think somebody's going to have to do that because we're limited in the bills that we can, the amount of money that we can approve spending.
And of course,
without approval from the Budget and Tax Committee.
spending is always a concern. I know it's been brought up in other bills even today, but studies have shown, especially studies by the Safe Homes Domestic Violence Center, that the cost of domestic violence exceeds $8.3 million annually, and that victims of domestic violence lose a total of 8 million days of paid work each year. So although there is a cost concern and also a concern on how to adequately monitor these registries, just like we have navigated that for the sexual offender registry and also for gun registries, the impact on your constituents and their ability to work days, no longer losing money, I think that there is a payoff on that sense.
Don't get me wrong, I think the bill is well conceived, but we are facing serious budgetary problems this year, and $2.5 million in this climate is an awful lot of money for which we would have to get permission in order to pass a bill along these lines. Thank you.
Understandable. Thank you.
Thank you, Mr. Chair. So thank you for coming and testifying on the bill. I just have a couple quick points I need to get clarification on. Can you or can you not go and currently under, do like a Maryland judiciary case search, which would show these infractions?
You can, and to that point, again, going back to the same Governors of Family Violence study where they are talking to these survivors and trying to identify issues with the system, one such issue was being able to navigate case search, Maryland Judiciary Record Search and Case Search, where it is not easily navigatable.
Navigable.
Navigable, thank you. It is not easily used. And as a prosecutor, if I fail to pull an NCIC, a criminal history for somebody before a bond hearing, my quick response is let's go to case search and let's try to look up their criminal history, at least in the state of Maryland. And even so, I am presented with numerous individuals, especially common names.
Understand.
If you don't know their exact date of birth, you're also
If you're going to date them where you have that, I mean.
Well, I can confidently say I know my husband's date of birth, but I don't know if I knew it when I was dating him.
Okay, so here's my biggest concern with this, and it's not that the intent of this bill is not noble, just, or any of that, because I'm a huge proponent in supporting victims and advocacy. My concern is that when I'm looking at it, it deals with the family law article and it talks about domestic violence. And domestic violence in the family law article is termed differently than it is in the criminal article. Because in the criminal article, if I'm not mistaken, it says that it can just be cohabitants who are not in a intimate relationship. And that is a bill actually that I've had in, and I have it in this year, because that needs cleanup, because it creates a problem in that if Chris and I live together, Senator West and I live together, I'm an Eagles fan, he's not, he's upset because Sunday the Eagles win, we have a little dust up and it becomes physical, even though there's no intimate relationship, because we reside together, it's listed as a domestic violent event. Correct?
You are correct.
That's a problem.
I agree with that.
So I'll be looking for you to come back down on my bill that clears that part out, because it's in this year and it needs to be cleaned up, because it is not the intent of DV law to incorporate that. And we should have that should never be a separate definition in the family law article and then go to the criminal code and it's different.
I agree with you, and in my own research, and it's obviously noted even within this bill, which sections to go to, and I noticed the same concern about cohabitants and what that means.
Because that would mean that I already had one strike because the Eagles won this year. The Eagles are going to win next year. That's twice. And then the third time, I'm going to be on a registry, and Chris and I were never even intimate. Not that there's anything wrong with that.
Yes.
But do you see my problem?
I absolutely see your problem. And I think that on the forefront, if that's something that can be fixed and amended, that would be great.
Okay.
On the backside, as a prosecutor, when arguing in court about that, we do look at the legislative intent, and we pull legislative notes to see what the legislative intent is.
But the legislative intent versus the actual letter of the law are two different things many, many times.
Yes.
And this is a prime example that needs to be corrected. So thank you.
I agree.
No, I appreciate that. Thanks. All right.
Thank you.
Further questions from the committee? He's always like that, so just tired, yeah. No, okay. All right, further questions from the committee? All right. Thank you both very much. Thank you.
Thank you.
All right. And with that, we have Ms. Taylor. Is the Office of Public Defender still here virtually?
I already have a strike because the Eagles won this year. The Eagles are going to win
Ms. Taylor, if you could, can we mute her real quick? So Ms. Taylor, if you're streaming the hearings, if you could just close down the YouTube tab and then come back in.
I just closed it.
Okay, excellent. Welcome.
Hello, how are you? I guess I'm the only person here in opposition.
Well, the only one signed up.
Okay. Well, Benita Taylor from the Public Defender's Office. We're in opposition of Senate Bill 650. We have submitted written testimony, as well as has, I believe, the ACLU, and we would urge the committee to read the testimony. But what I'd like to say is registries do not deter crime. Registries do not deter crime. Registries do not make the public safe. I heard the previous testimony in favor, and anticipating that, I asked some of the young attorneys in the office and my nieces, and none of them check even the criminal search for anybody that they're dating. Nobody does. That's not something that's in the dating protocol handbook for young people. They look at, which was testified, they look at Facebook. They look at LinkedIn. They look at Instagram or any other of these X that people look at, but they don't look at a registry. They don't even look at the criminal registry, which is available and it's public. These crimes are public record. Anyone can look at them. But what this registry does is more than that. This registry also will put people on the registry who are into a plea agreement or nolo contendere. A lot of the domestic violence cases are settled. And this bill would put a crimp in settlement agreements. If I know I'm going to go on a registry, even if I do nolo contendere, I don't take a position, I say you have enough information, I just want this to go away, you're still going to be on a registry. If you enter a plea of guilty, because you've negotiated something with the state's attorney, you're still going to be on the registry. You're even going to be on the registry if the victim says, I don't want the person on the registry. There's nothing that says that the victim can say, no, I don't approve of the person being on the registry. And the reason why I would say that is because on
Ms.
this
Taylor,
registry, you have
Ms.
the
Taylor.
registrar's name, their residence, but the date and
Ms. Taylor.
description of the crime for which registration is required.
Ms. Taylor.
That violates not only the defendant, but also the plaintiff's privacy, because you have to give a description of the crime.
Okay.
On the general website.
All right, I guess
public for crime.
We're going to punch right now then. All right. Sorry, Ms. Taylor, time's expired. And there are no questions from the committee that I can see.
I'm sorry, was I talking all that time and I was muted?
No. We heard you the whole time. I guess you couldn't hear me. You can't hear us. You can't hear me. Can you just type to her a message?
I appear to be, hello?
Let's mute her. Let's pipe her out before she says something. It's not. Okay, sorry about that. We'll follow up with her on email. Can no one hear me on this thing? Okay. All right.
Zoom is, and the YouTube feed went down completely for judiciary. We can hear them, but they can't hear us. Oh, good.
Oh, that's fascinating. Yeah, I see the little notification. Maybe we'll call it OIT.
Yeah, let's move.
I recommend we adjourn until every microphone is yours. It's only my bills left.
Human pet remains. So let's go over to Senator McKay would be next, but let's wait until we can get operational here. Thank you.
No, that's.
All right, it looks like we're back on line. So Senator McKay, you're up with Senate Bill 616.
No, it's not working.
Okay. Looks like we're back on board. All right, Senator McKay, you're up with Senate Bill 616.
Now, it is noted in the play Macbeth, written by William Shakespeare, that how long it's been, and we've worked very, very hard tonight, but the labor we delight in physics pain. This suggests that the work we enjoy can ease our suffering as we make even a long day feel worthwhile. It has nothing to do with Senate Bill 616, but I thought I would share that as we continue. So Senate Bill 616 will alter the definition of permanent cemetery to include a cemetery owned by a family or a religious organization. It will also prohibit any person from tampering with the human remains interned in the cemetery, and will alter certain penalties relating to the prohibition against the removal of human remains from a burial site. There will also be prohibitions against anyone damaging, desecrating, mutilating, or storing or tampering with, trafficking or transporting human remains, as well as removing and attempting to remove pets from a cemetery. Now, my friend David Zinner had a little bit of a technical issue and wasn't able to sign up. However, I'm going to call an audible and just talk a little bit of some of his comments here. Unfortunately, we have 8 examples that cemetery desecration in Maryland has occurred, which is the reason that this bill is needed. In 2024, families were saddened to find out that the headstones of 59 loved ones over the Northeast Cemetery in Cecil County. In 2024, also a dozen human burials were dug up in the Rosa Bonheur Cemetery in Howard County. In 2023, anti-Semitic vandalism was discovered at a cemetery in Rosedale in Baltimore County. In 2021, Somerset County, Maryland, the Princess Anne Police Department is investigating the case of gravesite vandalism at St. Andrew's Episcopal Church. 2021 again, and 2021. You'll see this in the testimony. But unfortunately, with all of these, Senate Bill 616 will do the following. It will amend which currently addresses removing or attempting or removing human remains from a burial site by adding tamper with human remains and adding damage, desecrate, mutilate, store, traffic, transport human remains. And regrettably, this is needed because cemetery desecration of the 8 that we have witnessed. The bill does increase the fines and penalties up from 5 to up to 10 years of imprisonment, and up from $10,000 to at least to $20,000 at least, and then states that penalties escalate for repeat violations. In 10-404, the bill enlarges upon the current disorderly conduct violation and adds malicious and abusive activities. The bill also proposes that any cemetery desecration violation is a felony, no longer a misdemeanor. The bill also provides the denial of any license, for example, a real estate license, if convicted of tampering or removing the bodies in a cemetery. It does allow for civil actions in a court to recover damages. And of course, we've added unauthorized removal of pet remains. As I said in another bill, how we treat the dead and how we treat these souls will have lasting respect for those families, but also telling the future of our history. These monuments will be here for years. Paper will burn up. The recordings will be gone. but the monuments will tell, and how we treat these cemeteries where the monuments are will also determine how we will be seen in future generations. I urge a favorable report for Senate Bill 616, and will answer any questions that you may have.
Excellent. Questions from the committee? All right, great. Thank you very much. Do we have we have someone joining us virtually? Jennifer Johnson, is she in the room?
Yep.
And Jesse Bennett? Mr. Bennett, you're up. Welcome back.
Thank you, Senator. Gotta make sure again, my name is Jesse Bennett. Good evening, Chairperson and members of the Judicial Proceedings Committee. My name is Jesse Bennett. I'm a member of the Maryland Cemetery Legislative Advocates. I'm also a volunteer research coordinator for the historic 153-year-old Mount Auburn Cemetery located in Westport, Mount Winans community of Baltimore City. Mount Auburn is Baltimore's oldest African-American cemetery. We're on the national and Maryland's list of historic places. My great-grandfather is buried at Mount Auburn. My duties at Mount Auburn include locating the burial sites of unmarked graves of family members. Often during the past 12 years, I've engaged in maintenance supervision of landscaping at Mount Auburn Cemetery. We will certainly benefit from the expansion of the penalty definition of our property due to incidents in the past. In 2000, a group of homeless people built and inhabited a large shed on our property. Our property is currently subject to vandalism of grave sites, damaged fencing, and graffiti, despite no trespassing signs posted around our property. We need help to protect our property with stronger legal support, which Bill 616 will provide. Please support and issue a favorable report on Senate Bill 616. Thank you.
So, thank you very much. All right, Ms. Johnson, you're up.
Yes, good evening again, Chair Smith and Vice Chair Wallstreicher and the entire committee. Thank you again for allowing me the opportunity to speak with you this evening. I do ask that you give Senate Bill 616 a favorable vote. Again, I started the Friends of St. Peter's Cemetery in 2023. The cemetery is located in West Baltimore, and it started in 1851. Years ago, we did have some desecration to the cemetery, and Judge Thomas Ward stepped in and blocked that. You know, unfortunately, we live in a society where sometimes people don't know right from wrong, but I dare say everyone would agree that desecrating a cemetery is wrong. I wouldn't want it to happen to my family, and I wouldn't want it to happen to anyone else's loved one. So I ask that you give 616 a favorable report. For anybody that does decide to desecrate a cemetery, there needs to be penalties. Thank you.
Excellent. Thank you very much. Questions from the committee? Senator Sidnor.
I'll wait till the sponsor gets up.
I thought we agreed no questions. No, sir. Go ahead, sir.
I know that's an easy one, and I welcome Ms. Johnson. We've had conversations in the past. But I was listening to the testimony of your witnesses, and then as I'm looking through the bill, the bill does it address what it is that they're talking about, which is essentially destruction of property versus, as I read, this is about, when I think the term desecration, I'm thinking of the human remains, not necessarily vandalism.
So I think on page 4, line 17, says, unless authorized by law, a person may not damage, desecrate, mutilate, store, tamper with, traffic, or transport human remains. And if you feel it needs to be stronger there, but it seems to me that handles.
On page 4, lines 14 through 17?
19.
17 to 19.
The part was,
Oh, line 1. Oh, okay, got you. Thank you.
thank you.
Appreciate it.
All right, additional questions from the committee? Oh, did Senator James, she just left. Okay. With that, that'll end the testimony and the hearing for Senate Bill 616. We'll now move on to Senator Folden with Senate Bill 625.
$625? That's fine, that's fine. Have a seat. Hello. Okay. Mr. Chair, Mr. Vice Chair, remaining colleagues of Judicial Proceedings, it's good to see you. For the record, William Folden, Senator for Frederick County, here to present to you Senate Bill 625, the Police Accountability Investigation Records relating to unfounded and exonerated complaints. So I'm just going to give everybody a little snapshot here. Earlier this session, we were talking about removing charges from convicted felons, releasing people from convicted sentences. The threshold for investigations on law enforcement is far lower than any bar in a court proceeding. However, what we have is, in the general public, we have people that see that maybe police officers aren't their friends. Police officers overwhelmingly deal with the general public in probably, I'll say 95+% of their encounters with the public are when people are having not their best moments and are in need of assistance. And sometimes they don't want the assistance, so they become more aggressive. The encounters are not always going to be favorable. They're not always going to be pleasant. They are going to be fact-based in the law enforcement there to enforce the laws and handle the situation that they are tasked with. SB 625 simply looks to create the opportunity, because currently any complaint filed against a law enforcement officer in the state of Maryland, whether it's founded, unfounded, sustained, not, whatever you want to call it, if it's if it's unfounded or exonerated, it's still on their record. Why? If I go to any of your professional occupations and I go to your boss and I accuse one of you as being a sex offender, that you have violated someone at a playground, let me take that back. If someone were to come in and make a complaint, an allegation against a law enforcement officer in the current writing of the law, and say that this officer is a sex predator, is a child predator, he sits at playgrounds and watches kids, and they investigate that claim, and it's found to be absolutely absurd and unfounded, that allegation still stays on that officer's record, and it is open for public review. It is open for the public consumption to ask for that record, and it is okay for them to take that record and put it out on the internet and affect their children, and there's zero recourse. So why do we have a separate law, a separate rule for those who are protecting us when, in those moments when these allegations are proven to be false, they are unfounded and exonerated? Why are we going to keep those records on their file for the public consumption to be able to use them against the police officer and retaliate off of something that is absolutely unsubstantiated? That is wholly inappropriate and unfair. And I would request, I think any of you can see how inappropriate that is, that we've allowed this to remain on the bill in the law for the past 4 years now. We deserve to give our law enforcement officer professionals a better support mechanism than making sure that even frivolous, unfounded, and exonerated complaints lodged against them are open for public consumption and have to justify their every action when most of their interactions are with the public at not their best moment. And with that, I would ask for your support for Senate Bill 625 and your favorable recommendation. I'll turn it over to my panel.
Good evening, Chair, Vice Chair, and the committee. I'm Veronica Bruns. I'm the treasurer of the State Law Enforcement Officers Labor Alliance, also known as SLEOLA. I'm also a corporal with the Maryland Natural Resources Police. SLEOLA is the exclusive representative for over 1,700 officers, state law enforcement officers, covering 9 agencies in the state of Maryland. SLEOLA believes that it is imperative to maintain a procedure that holds both accountability and fairness in how law enforcement officers who serve and protect our communities are treated. Law enforcement officers throughout their careers should be held to the highest standards, but should not be unjustly hindered by complaints that have been thoroughly investigated and deemed to have no merit. SB 625 will ensure that law enforcement officers who have been exonerated or cleared of misconduct allegations maintain protection on their reputation and professional future. It would ensure that the record of an allegation where the officer is found to not be at fault will not continue to impact their career indefinitely. The proposed 3-year timeframe provides a reasonable balance between ensuring a thorough investigation and allowing for the restoration of an officer's good standing after a complaint is deemed unfounded or the officer is exonerated. SB 625 will also help to restore public trust in police accountability, the disciplinary process. It will ensure that our officers' records reflect only relevant and substantiated complaints. This would allow for the public to have more confidence that our officers are being held accountable for legitimate and substantiated complaints and findings. While doing this, it upholds that officers are still afforded their rights to fair treatment and due process. This will foster morale and assist with recruitment and retention in law enforcement, which is so needed. For this reason, SLEOLA would like to thank the sponsor of the bill and ask the committee for a favorable report for this important legislation. Thank you.
Good evening. I'm Mike Shire. I'm a police officer. I've been a police officer for 21 years. I'm an attorney here in Maryland, representing the Maryland Fraternal Order of Police. We represent over 20,000 active and retired police officers throughout the state. As you all know, police officers serve under intense scrutiny and pressure. We're tasked with upholding the law, often in challenging and unpredictable situations. When a complaint is lodged against an officer, it's essential that the process of dealing with that complaint is fair and just. False accusations and complaints that are later determined to be false or without foundation can unfairly tarnish an officer's reputation and career, even if they had done nothing wrong at all. Even more problematic is that the more work an officer does, the more likely they are to get complaints, founded or unfounded. But by leaving these unfounded and exonerated complaints on an officer's record, you're basically discouraging them from doing work because these records are open to public inspection, something that is new. We are unique in public service in that our disciplinary records are open to public inspection. Do not discount for a second the additional stress that is placed on officers when they're notified of a complaint, even if the officer knows that the complaint is going to eventually be found unfounded or they're exonerated. This is not a small issue. There's a general issue of fairness. We protect the rights of individuals who've been falsely accused of crimes, allow them to have their records expunged, and as the senator mentioned, we allow those that have been found guilty to have their records expunged. So why is it that a police officer at the lower level of an administrative hearing cannot get unfounded and unsustained complaints expunged from their records, but a criminal at that higher level, a criminal proceeding who's been found guilty, can get their charges expunged? That's just not fair. It is hurting our morale. It is hurting our ability to hire and retain police officers. We've had committees come forward trying to find out why this is happening. We're telling you why this is happening, and we're urging you to give a favorable report to this piece of legislation so that we can take back some of this, this unfairness that has been put upon us. Thank you.
And for the committee, I want to give you, I have a personal example of something that is very low level, but it's still there. I had a person during my campaign used it, they weaponized this and reported me as tracking their vehicle, that I was putting stuff on there, following their movement, really like way out there things, but accusing me of using my position in office as a police officer in ways that are criminal. And even though it was found to be unfounded, not sustained, all that, it's still going to be on my record if somebody goes and pulls it. That's not right. That's wrong. And if any of you in your professional capacity had something that was unfounded when someone made a complaint on you that was open for public inspection at any time with zero limitations on what they could do with it once they got it, whether they could put it on the internet or anything else, I don't think you'd like it either. So I would ask for your favorable report. Happy to answer any questions.
Senator West.
Thank you, Mr. Chair. So thinking about expungements, this sounds pretty much like an expungement in a different way, but the same idea. So right now, if someone is accused of committing a crime and is found not guilty, that person is able to get the offense expunged from his record after a certain period of time. Isn't that right?
Correct.
And if someone is convicted of a crime and serves time, in the case of many crimes, once the person gets out and an appropriate period of time has passed, that person is able to get the entire crime expunged from his record.
You're absolutely correct, Senator.
So we're not talking here about a policeman who's committed a crime or he's even been accused of committing a crime.
We're talking
It's
about
just a
administrative penalty, administrative investigation.
So I don't see why what's sauce for the goose shouldn't be sauce for the gander. I've always supported expungements. And in appropriate cases, and I found most cases to be appropriate once an appropriate amount of time has passed. So don't you see the parallel between your bill and the expungements to which we have agreed to enact over the last couple of years?
I mean, I see a similar parallel in what you're saying. I would say that the threshold and the level the required for a conviction in an administrative investigation is far lower than any criminal investigation, and yet these remain open for public consumption and to do with as they please.
Okay, thank you.
Questions from the committee? Okay, excellent. Thank you both very much. Thank you, Senator. All right. That'll conclude the hearing for, actually, hold on, I'm sorry. That'll conclude the proponents, the testimony for the proponents of the bill. Is Ms. Morris and Deborah is not here. Ms. Levy?
Ms. Morris is virtual.
I will do virtual. All right, Ms. Morris, welcome. You're up.
Thank you very much. And I listened to what was being said, and I'm going to say to those two persons, you know, if you don't know what it's like to have a daughter dead in the ground and no justice, and know what it's like to fight for a decade on behalf of other individuals who often have accused justly police officers, even though we have really good ones, but failed to see any true justice occur. So my name is Reverend Marguerite Morris, and I'm here to testify in opposition of Senate Bill 0625. I'm with Community Actively Seeking Transparency, and for Kathy's sake, where in memory of my daughter, we now have a law on the books called the Catherine Morris Death Reclassification Act. What we need to do with this bill is put a hard stop to it. Why? Because of the major importance of identifying patterns of behavior. And this bill seeks to remove or block evidence of those patterns. These very patterns that they themselves use, they call that behavioral analysis. And in criminal profiling, it goes to what a person's thinking dictates his or her behaviors. And some key points about the importance of behavioral patterns is that in criminal profiling, because if someone breaks the law, we do want to, you know, they've done something wrong. They look at their patterns, studying their patterns of actions, help investigate and create a profile that outlines their characters and their behaviors and the tendencies of those individuals. We talk about the modus operandi. That's analyzing the specific details about a crime that was committed across multiple incidents can reveal a consistent pattern of behavior. And all my advocating on behalf of whatever with my child, it was always talk about the pattern of behavior, and that's what they're looking to remove. And yes, linking, identifying a single perpetrator or linking the cases together is so important. and I want to move forward. So from a blog found on American Military University site, Signs of an Organized Criminal. And I know I'm not trying to offend all officers, but there are some bad officers out there. And we fought hard as a state to come up with a police accountability bill. We fought hard as a state to put down Leobor. So now to compare the expungement of persons to this bill, it's not right. So this type of offender usually has an above average intelligence, is gainfully employed, is in a committed relationship, has no history of mental illness, and is socially competent. So why are we looking once again seeking to place police and other law enforcement professionals above what is the reasonable expectation of others? In closing, please do not allow this bill to go through, for in doing so, we'll be undoing what progress we've made towards needed, stronger police accountability. I implore you, hold them accountable. There are instances where people are, yes, sometimes unjustly accused, but the majority of time for impacted persons, it's hard to prove our cases. It's hard to get justice. It's hard to be heard. So let's not turn that clock back. Right. And I really thank you for this time this afternoon.
Excellent. Thank you very much, Ms. Morris. Questions from the committee? All right, seeing none, that will conclude the hearing for Senate Bill 625. We'll move on to Senate Bill 626, the final bill of the day.
Okay. Mr. Chair, Mr. Vice Chair, esteemed colleagues, I think the last bill of the evening, is that correct? This is going to be an easy one. You guys are going to be ready to move favorable right away. All right, so what I have before you today is SB 626. This is a local bill, and this refers to the, for the record, William Folden, State Senator for Frederick County, and this bill refers directly to the salary of the Sheriff of Frederick County. The Sheriff of Frederick County salary has not increased in over 18 years. It has remained the same, and while other sheriffs across the state have been moved with favorable especially local courtesy, this one has not been the same. This is about a position, not a person, and it's important to understand that for the office of sheriff that has a full service responsibility, that in short, that is, they are the county patrol, they are the local law enforcement, they are the keepers, the safeguardians of the corrections facility, of the courthouse, as well as civil process. It is a full service entity that employs over probably nearly 400 personnel now. The salary currently is $125,000. Through vigorous discussions amongst our delegation, it was determined that originally the bill in its language came out that it was going to be consistent with the state police lieutenant colonel. And through this discussion, it was determined that we would shift that to 82.5% of the current state's attorney for Frederick County's annual salary, including any increments and salary adjustments as authorized. And in short, let's see, I'm going to make sure I don't miss anything. It would move the current salary, as you can see in your bill, to $187,313, which is nearly consistent with you took a cost of living adjustment for 18 straight years, now in the 19th year. And with that, I would ask for your favorable report on this local courtesy bill, and there is a delegation letter of support in everyone's folders.
Excellent. Questions from the committee? Senator Sidnor.
No, I know during your testimony, you said it's not about an individual, but I think it failed because it's about an individual.
Correct. That's why it failed in this body, but it's still, I will say that I have never before been so woefully it was this is a local courtesy. And when the local delegation, it is very uncommon, unprecedented for this body to take up and oppose to a local courtesy bill that is about the position, not the person. And the people that voted on that and opposed that did it for personal motives or what they were hearing, because no one that took up issue with it lives in Frederick County. No one took up issue with it that has, many people took up issue with it because of the program that he supported, which is a federal program and is within his right. They didn't do that when Sheriff Gaylor wanted a pay increase.
I'll see what happens with him.
Okay, thank you.
No, we passed this in, not last year, but the year before. We passed this bill, and then obviously it ran into problems. So, and yeah, I mean, we passed it though. I mean, like.
Yeah, we passed it.
Okay, Senator James.
I just want, it's prospective, so that makes it particularly not about the individual, right?
Correct.
We're not giving a salary increase to an incumbent.
Yeah, that's right. It doesn't happen until after the next election.
Looking to the next
Correct.
election, and the voters will
Yep, thank you for
weigh in.
pointing
I just
that
want to clarify that. But I got to just say, I don't really, it's late. The bill still ties it to the police lieutenant colonel, but you're going to change it or something?
We took that out, yeah.
Okay, I just
it's
didn't.
tied to the county state's attorney's
My
salary
staff
now.
just didn't
Yep.
get that part of
Yep.
it. Okay,
Yep.
very good. Thank you, Mr. Chair.
Thank you.
All right.
Thank you, Mr. Chair. Thank you, Senator. With it being a local bill, local delegation, having a vote, can you speak to the vote? It looks like it was not partisan. It was actually.
Yeah, it was a bipartisan it passed the delegation 13-2.
13-2. So it certainly wasn't a
Right.
party line.
There was one Republican and one Democrat that voted against it.
So I think that's important to note. Thank you, sir.
You passed it, didn't you? Yeah, he passed it, right?
Only the 3 people that were most recently the House.
Hello, House. Hello, House. But now you're in the Senate.
Okay, I'm going to.
We did it though.
I look forward. Ready to move favorable?
That was like the Hindenburg over there. That thing was on fire before it came over there, man. All right, with that'll end the hearings. That's the end of Senate Bill 626. That'll end the hearings for the day. We've got nothing. We'll come back after floor. We're gonna. Yeah, let me gavel out first. So we'll just come back after floor, and we're gonna have bill hearings. I think we have 9 bill hearings.
Yes.
And then we're gonna vote so that Friday can be an administrative day. So that's that.
Yeah.